Already, petition onwards, the bank, opposite party bank has sanctioned loan with the husband of the petitioner. And husband expired on 10/10/24.
What is the date of loan?
Date of loan, minor. That is 13/31/12 8 lakhs and 21/12/21 3.9 lakhs.
So you take emergent notice. Let us see what the bank will say.
I don't know. I have heard it. Tomorrow is the he is ready to pay from the amount to the bank. Tomorrow is the auction date.
Let auction take place. Now you have come. When have you filed the petition?
Petition 2nd February.
2nd February. See, all the when the notice was auction notice was issued.
Auction is 3/1/26.
3rd of January. Then what
he has no.
No, we'll have to do. Let us.
Protection.
Auction, if any, shall be subject to outcome of the petition.
Item 2.
Yes.
For the bank.
Sure, the bank. Where is your friend? We have posted being spoken to actually. They should write it for being spoken to. There was no IA. No IA. This court.
Even they have not supplied the read copy on that day.
No, that apart, there is no IA in that. No IA. Item 2. Item number 2. That's what. Item number 2. Where is the IA? You have obtained interim order without filing IA.
Sir, I have filed yesterday.
Yesterday, after filing of that, after we passed the order. Take rest. We'll call it after 5-10 minutes. Please sit now. Let's sit. Pass over.
Item 3.
Another item is from development in the bank. I'm a petitioner going to people some channel. Let him tomorrow.
My lord, property has been sold yesterday.
So it is sold.
My lord.
Then we can't make that order, no? But don't confirm it.
My lord.
Don't confirm it till next date of hearing. But position is given, no.
No, position yesterday sold. He has deposited as the record money. 25% he has deposited. Time is there to deposit.
See, when under Order 21, Rule 97 of CPC, Order 21, Rule 89, setting aside under Order 21, Rule 89 of CPC, when an auction sale is set aside, the buyer should be given solatium. That's what Bela Banerjee, Supreme Court said. Similarly, if you want to deprive him the property which he has bought because he happens to be the highest bidder, you have to pay something to him. Are you agreeable with that proposal? And you implead the buyer. Give the details of buyer.
Today morning I have got the instruction. I will collect everything.
Now you collect and give it. Pass over. Yes, next. Otherwise, one more day will be wasted. Yes. And you may confirm that sale also, so that he will lose that property. Therefore, let us see. We can't allow the house property to be sold that way. Yes.
Item 4.
I want 1 day accommodation because I have been disengaged from the panel.
He wants
the last occasion also.
Anyway, some difficult. Call next week with the request. Yes, next.
Item 5.
No, there's a delay, my lord. It's a post-retirement benefit claim, my lord. 196 days delay, my lord.
196 days in filing the appeal.
Yes, but
on merits, what you have got there?
Yes,
what
merits, my lord, the claim is, my lord, post-retirement benefit. They were given, my lord, temporary status in 2012.
We'll issue notice. The next date will condone the delay. If you have any objection in the meanwhile, you may file. Issue emergent notice. Learned DG is requested to accept notice for all OPs.
Lord, 4 is notice to issue.
State capital sends emergent notice to 4. 1 to 3, Mr. Manti. 4 emergent notice. Yeah.
Item 6.
6, my lord, I have sought for a modification of your lordship's order. That tribunal's order has been upheld in this application. Similar matter which has been posted with the Honorable Appeals Court filed by the Union of India, that has been dismissed, and accordingly this court has been dismissed our application. Only the
Coordinate bench order.
order, my lord, dated
Whose order?
order 11/8/2025, order number 5.
Of coordinate bench.
Yes, ma'am.
My Lord Justice Tamim Sahu and my Lord Justice Das Tathya.
Okay, therefore it has come before us, no? What happened? What
The
modification?
last paragraph, you lordship may kindly see, the order passed in the case of Madan Mohan Patnaik. Instead of Madan Mohan Patnaik, this Sushant Kumar Mishra. Only that is the.
Learned senior panel counsel appearing for the petitioners submits that in the penultimate paragraph of the order dated 11/8/2025 rendered by the coordinate bench while disposing of the WP, the name of Madan Mohana Pattanayak is mentioned instead of
Sushant Mishra.
Sushant Mishra. And that needs to be rectified. First of all. Other side does not have objections.
Well, it is nobody appeared in that case, my lord. That has been dismissed.
The submission is acceptable. And therefore accepted. First one. Registry to effect necessary change in terms of this order immediately and supply a free copy if applied for.
Same order in respect of the other matter, my Lord.
Two matter, my lord, one matter, my opinion.
In both the matters. In both the matters. Yes.
Item 7.
7, may please your lordship. My lord, in this case, I am for the railway, my lord, the petitioner here before your lordship, the Department of Railway. My lord, both the matters are connected matters, my lord. There are two writ petitions. In first case, my lord, I am appearing, and in second case, my lord friend Mr. Bhokta is appearing, my lord, on behalf of the government of India. He has some personal, my lord, health
You want
issue.
time? You can say directly, instead of saying all this
Replied, my lord,
story. Yes, call after 2 weeks at the request of.
obliged, deeply obliged.
Item 8.
Item 8, my lord, the petitioner is the workman, my lord. He is challenging the award of the learned Labour Court Bhubaneswar under Annexure 5.
Award is what?
Award is, my lord, I was illegally terminated from my service without compliance of Section 25F of the ID Act.
25, yes. Retrenchment compensation.
Yes, my lord. Thereafter, my lord, the learned Labour Court came to a conclusion that there is this is not a case of termination, rather the workman has voluntarily abandoned his service.
Job.
Yes, ma'am. Then, my lord, the fact is that in the year 2016, that is in the month of August 2016.
August 2016, what happened?
My lord, the petitioner was issued with the appointment order as executive logistic, my lord.
Appointment is of August.
Yes, my lord. Appointment is of August 2016. And well, to that effect also, the offer of appointment I have, my lord, enclosed in the affidavit at flag B. Thereafter, my lord, the petitioner was working under Aditya Care Hospital. Thereafter, it moved to a new premise, that is Quality Care Hospital.
Where?
That is to 1.5 to 2 kilometers away from the Aditya Care Hospital. Petitioner was working in a general store of that hospital, which is 200 to 300 meters away from the hospital. Petitioner was issued with the order of transfer, but it was not communicated to his present address where he was residing, for which he was unable to join in the new place of posting.
How long it was?
My lord, 22/11 to 22nd of November 2018, it got shifted. Thereafter, my lord,
when the order was issued,
my lord, they have terminated me by way of refusal.
When the order of transfer was issued,
transfer order was issued, my lord. It was sent to me by mail from in the month of November 2018, my lord.
When?
My lord, the exact date is, my lord, The last communication was made on 6th of December. Previously, they have communicated me, but not in my present address. Rather, they have got that address from my Aadhaar card. Whereas in offer of
Even in Aadhaar card, it has presumptive value.
But my lord, in offer of appointment, my lord, the address given was different.
Offer all right, but in Aadhaar card, after you furnished, did you inform them? Even when Aadhaar card address is given, correct address is the earlier address only.
That I have no, my lord, I need to take instruction on that.
Of abandonment of service.
My lord, because
To extract money from the employer. That's all.
my lord, I have worked there. I have worked. I have put my biometric.
Practice earlier you used to have all the messages in email or not?
They have
They have
sent
sent it in email or not?
my lord, they have said that they have sent it me through email.
Dismissed, agreeing with the
My lord, only contention is that there no inquiry has been conducted to.
Why inquiry?
No,
You
they have
abandoned the service.
My lord, have a glance to page 44, Exhibit G, my lord. My lord, but in the said letter it is mentioned, that is Exhibit 8, 6/12, 2018. In the said letter it is mentioned that if the management does not receive any communication from the workman on or before 6/12, 2018, the management will be forced to presume that the workman is no more interested to continue in his job and compelled to take disciplinary action against him, which may result in termination of service. And thereafter, my lord, they have also agreed that it is my lord, in page 46 of the writ petition, that is
It is 227 petition. Because after labor court award you are coming.
my lord.
Dismissed.
My lord,
Fines.
my lord, last submission.
Sixth matter. Item 9, please go on, please. Agreeing with the reading of this. This is an intra-court appeal and therefore appeal arising by and therefore restrictions of the scrutiny to apply. Petition being under Article 227, the other companion Article 226 having been ornamentally applied.
My lord, this honorable court has directed, my lord.
Item 9.
May I please, your lordship? As directed by your lordship, the last occasion, the resolution plan, even though we do not rely upon it, but since the court wanted to produce the same, copies thereof have been provided to the other side, and for completeness of record, we have also filed it before your lordships. They are there. But before I proceed any further, there was another part of my submission on the last occasion, that there was a prayer which I did not want to pursue. I have filed an affidavit to that effect. Prayer 2, yes. I only pray that your lordship may record that the petitioner does not intend to proceed with that. He will seek his remedy elsewhere with regard to that part of it.
No, you have abandoned that prayer other day.
I have given an affidavit today, my lords. I said that I will make an affidavit. And I am giving that affidavit today, wherein I have stated that since it's a money claim and your lordships in a writ petition may not go into that as to how this amount has been illegally deducted or whatever, hence I be granted leave to pursue that remedy elsewhere, either with them or with in a properly constituted proceedings before the civil court or whatever other remedies may be available to
That's right.
petitioner.
But if we replay the other day's proceedings, I'll ask them to replay now.
Yes, my lord. Your lordship may see that, and I had specifically stated. Your lordship said that you file a memo. I said that
you said you will file affidavit.
I will file an affidavit. I have filed an affidavit.
Where is this? You did not say one word that we will pursue that remedy elsewhere. And you unconditionally abandoned.
That is exactly the reason why I did not want to file the memo on that date, because I wanted instructions from that friend. I leave it to your lordship as your lordship pleases. I have made the affidavit. If your lordship feels that it is warranted.
Otherwise, they may mistake the counsel.
Yes,
he told.
Yes,
that will give up this prayer, maybe under the impression that he can pursue it elsewhere.
Yes, my lord, what my submission is, my lord, now that my learned senior has filed an affidavit,
that can be taken on record. The only difficulty is, my lord, that liberty which he is praying for, that he is praying.
Yeah.
So, my lord, that has to be considered in view of the fact that, my lord, there may be limitation and other things. So, legal remedy, no liberty is.
Intentions will keep.
Yes, my lord. My lord, in that case.
Because Mr. Mukherjee is justified in saying that.
Yes, my lord.
He says that I will not pursue this means he will not pursue in this jurisdiction.
Yes, my lord. I understand, my lord.
Go to the earlier order.
Yeah.
Why the order dated 2/2/2026 we had said as that. Learned counsel, senior advocate, Mr. Mukherjee, had submitted that his client would not prosecute prayer number 2 herein, which reads as under. First of all. Next one. Now he has filed an affidavit. Now counsel appearing on record for the petitioner has filed an affidavit dated
9/2/2026.
9/2/2026 to the same effect, but subject to the condition that his client would be prosecuting the said claim elsewhere in accordance with law, regard being held to the limitations which the writ court has. First off, the prayer is innocuous. The request is innocuous, and therefore the same is granted with liberty as sought for. First, in pursuing the remedy in respect of second prayer, before in the appropriate proceeding, all contentions of both the sides are kept intact.
Now, my lords, come to the first one.
Yes.
Now, since your lordship had certain doubts as to what were the contents of the resolution plan, I will first of all take your lordships to the resolution plan. Kindly take the resolution plan at page 43. This has been filed by memo dated 4/2/2026.
Page 43.
Page 43. Internal page 43 of that document.
Can you just refresh our memory?
Well, it's like this. There was a CIRP proceeding under that in respect of the petition, in respect of the corporate debtor that is by the same name as the present petitioner. At the application of one of the creditors, a CIRP proceeding was initiated, and in that CIRP proceeding, a resolution professional was appointed, and a committee of creditors, as is emphasized under the scheme, a committee of creditors, they proposed a scheme. I was one of the resolution applicants.
You were one of the resolution applicants. There were many others also.
There were others also. Now, my application was ultimately accepted by the committee of creditors with a maximum percentage of voting, that is 77% of voting in my favor. And the resolution professional accepted the same and forwarded it to the NCLT for approval. That is the adjudicating authority. The adjudicating authority has accepted the resolution plan. And that is how the resolution applicant in me took the place of the earlier creditor.
Yeah.
In terms of the schemes of the IBC, once a resolution plan is approved by the court, all liabilities, etc., stand wiped out. That is the scheme of the code.
That is a doctrine of clean slate.
Clean slate. That is section 31 of the, I'll take your lordships to section 31 of the code. And that has been interpreted by the Supreme Court in a very elaborate judgment.
Justice Nariman's judgment.
Justice Nariman's judgment. And my lords, the same
Ghanshyam or something.
Ghanshyam Mishra. I'll take your lordships. Now, Ghanshyam Mishra, and that has been subsequently followed time and again. Vedanta Industries, etc. There are many, Bhushan Steel, etc. There's series of judgments on this point, which reiterate that once a resolution plan is approved, it should not be gone into again.
It's final.
It is final, because that would be like opening a Pandora's box. That is a language used by the Supreme. So that being the situation, my lords, as per the resolution plan, I became entitled to get back a bank guarantee that was parked with the Mahanadi coalfields. Opposite party, the contesting opposite party, my reputation.
That bank guarantee was given by your previous creditor.
The corporate debtor. Corporate debt.
Corporate debt.
Yes. He
was a company.
Yes.
Construction company.
It's a
mining company.
Yes, ma'am.
Fine.
They were
Basically, yes, my lord. They were performing the contract under the MCL, under which I was working as a subcontractor.
You appear for that company?
Yes. No,
I appear for MCL.
What's up?
I appear for MCL. They had
the company Sikol has not gone liquidated, my lord.
No,
has not been owned up. It's a growing concern for which this resolution plan was admitted.
Then what happened, Mr. Muthu?
So, my lords, I started on a clean slate, and in terms of the resolution plan, I lodged a claim for refund of the bank guarantee. That was initially held up by the Mahanadi Coalfields MCL on the ground that
guarantee is also part of the
resolution plan. I'll show it. That is exactly why the reason why I wanted to take your lordships to the resolution plan. I'll come to that later on. But since your lordship wanted a background, I'm just giving the background. So initially MCL took a plea that there is a claim against you by Mr. Patnaik's client.
So my lord may not hear him on my claim. My claim is independent.
Hear you.
So,
he is giving one broad idea to us. So we'll hear you also.
My lords, let him, if he wants to go first, let him go first, my lords. I'll take my seat because I don't want this repeated interruption.
Go first.
I don't want this repeated interruption.
No, I'm not interrupted.
Mr. Patnaik, we'll hear you also.
My lord.
Yes.
So, my lords, MCL said that has to be, first of all, there is a claim. So hence we are not in a position to release the bank guarantee. Almost simultaneously, Mr. Patnaik's client approached this honorable court in a first writ petition, saying that this money parked with the MCL should be released in my favor. In that case, this honorable court,
who is Patnaik's client? How he is?
He says he was a subcontractor under the corporate creditor. So he said that this money he is entitled to, and MCL negatived it. So he approached this honorable court seeking release of the money in his favor. This honorable court posed a very pertinent question. That what is you establish your relationship with MCL. And the matter was adjourned. Thereafter, my lords, the case was not pursued any further. It was dismissed for non-prosecution. In the meantime, a second writ petition was filed by the same petitioner on the self-same premises. No, not second writ petition. What he did was he went under section 9 to the commercial code, saying that there is this money is there, it should be restrained, MCL should be restrained from releasing that in favor of the petitioner, and he is entitled to that. That in that section 9 application, he also moved an application under Order 39, Rule 3. That application was rejected by the commercial court. Against that, he came before this honorable court in the second writ petition. First writ petition, non-prosecution, dismissed. There was a question posed, not answered, hence dismissed. Second writ petition against the order in Order 39, Rule 3.
No, first petition was dismissed for non-prosecution.
Non-prosecution on the premises because the court had posed a question which was not answered.
Is it reflected in the order?
It is reflected. It is reflected. Those documents have been filed before your lordship. So the second...
Then, it is not non-prosecution. It's on merits.
On the date, but for clarity, your lordship may see
Let us see the order.
Page 210. Your lordship may first see page 209 in my writ petition, page 209. Your lordship has it? Para 2. As there is no document to establish at least any connection in between the petitioner herein and the MCL authority, further the MCL authority has any authority authorizing opposite party number 4 in the transfer of work assigned to it in favor of the present petitioner. Mr. Mahapatra, learned counsel for the petitioner, seeks some time to bring amendment to the writ application and bring necessary documents to establish his case therein. The matter stands adjourned for 10 days. Now, over the page. Next order. In the same writ petition. Grievance of the petitioner in this writ petition is with regard to inaction like so and so. Para 3. Mr. Mahapatra, learned counsel, submits that the brief has been taken away by the petitioner to engage another counsel. Hence, there is no instruction in the matter. None appears with the petition at the time of call. Accordingly, the writ petition stands dismissed for non-prosecution.
There is a non-prosecution.
So, my lords, after this, the Order 39 or Section 9 application was moved before the commercial court.
You said that was also rejected?
Order 39 Rule 3 petition was rejected. They up against that in the second writ petition before this Honorable Court, which is at page 211, Annexure 11. Kindly see the prayer at page 211. Prayer in the writ petition. In view of the facts and circumstances and interest of natural justice, this Honorable Court may graciously be pleased to admit the order dated so and so passed in the urgent petition arising of shall not be set aside. The opposite party number 2 shall not be directed to stop release of the performance security deposit, retention money, final bill with respect to NIT 743 till disposal of Section 9 arbitration application. So that concerned my money, my bank guarantee. After your takes everything, Ghanasham Mishra, etc., everything is considered.
Morgan Stanley.
Everything is considered. Everything is considered. Now kindly come to page 230. Paragraph 16. From the pleadings, so also submissions made by the learned counsel with the parties, this court is of the view that there is no illegality or impropriety in the impugned order passed with the court below. That apart, this court is also of the view that in view of the suppression of material facts, so also giving false affidavit in the body of the writ petition as detailed above, the writ petition deserves to be dismissed with exemplary cost for such conduct of the petitioner. At this juncture, learned counsel for the petitioner, reiterating his submissions made earlier, states that he was not the counsel of the petitioner in WPC number so and so. That apart, the said mistake has crept into the body of the writ petition because of the communication gap. Mr. Patnaik begs unconditional apology on behalf of the deponent of the writ petition and files a memo for withdrawal of the writ petition. However, at this point, this court is not inclined to entertain the said memo. Admittedly, the subject matter of the writ petition is as to the legality of the interim order passed by the commercial court, and the present opposite party, who are the respondents before the court below, are yet to appear in the said case and have their respective say in the said regard. Hence, without delving into the merit of the case as to the maintainability of the said proceedings, since Section 9 applications yet to be decided on merit, keeping it open to the parties to have their respective stand and say before the court below, the writ petition stands dismissed. Against this order, they go to the Supreme Court, and at page 232,
there's also discord order.
It is
also
dismissed. Now, my lords, comes the next round. The next round is a Section 11 application filed before this Honorable Court for appointment of an arbitrator. That is at page 233. Same petition.
Now, what happened to that?
Dismissed at page 236.
Because they found out there is no arbitration clause, so it was dismissed. So my section 9 application became infectious.
Now,
Then I filed a
application.
reapplication.
Very unfortunate. Very
Generally,
very
there will be some anxiety.
I pointed out the conduct.
Yes.
Page 237. Page 237. Section 9 application was adjudicated by the court. It was argued on merits. And your lordships will find the same has been dismissed as infectious.
Infectious. Why infectious?
Because High Court held that there is no arbitration clause. Where is the question of Section 9 adjudication? Honorable High Court in Section 11 held that there is no arbitration clause between the parties. No, there is no arbitration
Saying
clause.
infectious may not be the correct expression.
Anyway, that's the language used by the court. So, my lords, actually it is rejected on merits.
Yes, anyway, the text of the order makes sense and we understood that the case is dismissed.
Dismissed, yes, my lords. Now, my lords, thereafter, he comes with a third writ petition to the subject. That third writ petition is not entertained. There is no notice to the other parties. The Honorable Court only says that there is a representation which is of the petitioner pending with the MCL. Let the MCL deal with and dispose of the representation. The MCL deals with the representation, rejects it. And that is how the present writ petition is before your lordship. Now, as far as my writ petition is concerned, I will not go into his writ petition now. I'll come back to my writ petition. Now, in my writ petition, Mr. Patnaik's client files an application for intervention. That application for intervention is considered by your lordships. And your lordship may kindly see that order.
Yeah. By us, by this bench only?
No, by a court bench. Yes, by a court bench.
There is number?
My lord, that is there on your lordship's order sheet.
Order is.
Kindly see order dated 1/10/2024. Order number 5. Kindly take from para 4. Kindly see para 4. Your lordship has it?
Yes, yes.
The writ petition has prayed for a direction to the opposite party number 2 and 3 to release the bank guarantee which is lying to the Bank of Baroda in their favor with further prayer to direct them to release the pending excess and the company, Mrs. Pristine Mega Logistics Park Limited, Private Limited, has come into picture being the successful resident applicant, client applicant in respect of Sikal Logistics Limited, the corporate debtor. The present intervener petitioner, as per the abutments, has entered into a subcontract agreement with the corporate debtor for execution of the tender work and for and on behalf of the corporate debtor. The bank guarantee in question has been given by the corporate debtor with the opposite party number 2 and 3 in relation to the execution of work of extraction of coal measure strata by deploying surface miners on hiring basis, mechanical transfer of the same by payloaders into tipping trucks and transportation of surface miner surface base to different destination of Hingula, Usipi, Hingula area being the successful tenderer. It surfaces on the record that the intervener petitioner was one of the operational creditors and such had submitted the claim before the National Company Law Tribunal, Chennai, and the final order passed therein has not been further challenged.
There it was negative.
Sorry,
there his claim was negative.
Yes, taking into account the above facts and circumstances giving rise to the cause of action for the present writ petition filed at successful resolution application.
Publication is rejected.
Is rejected, and the court thereafter also further goes on to make an order that there should be no impediment in getting my bank guarantee release. that order is also there.
Where is that order? Where is that order?
In the other writ petition, in his writ petition, order dated 11/2/25, your lordship can see. 25096, order dated 11/2/2025.
2025.
Your lordship has that?
Yes.
So in view of para 3(1), in view of the above, the court makes it clear that the pendency of the writ petition shall not be a bar for opposite party number 4 to approach the opposite party number 2 to release the bank guarantee. Opposite party number 4 is me. Opposite party number 2 is MCL. To release the bank guarantee, in that event, a decision in this regard shall be taken by the opposite party number 2.
Your client. Yes.
So this is the background of the entire case. Now, my lords, these two writ petitions are before your lordship. Now, my lords.
Yeah.
Your lordship sees in my writ petition, page 101.
Yeah. One. It is
your lordship says that this is the work order which was issued to the corporate creditor by the corporate creditor by the MCL. Your lordship sees the order is 5/1/2019. Now over the page, on page 102, there is a paragraph about in bold it is written performance security. Your lordship has that? At page 102, just below halfway the mark, below the halfway mark, there's a paragraph where in bold it is written as performance security.
You are right.
Performance security. First part of the security deposit should be 5% of annualized value of the contract amount, which comes to rupees 6 crores so and so, should be submitted by you within 20 days of LOA in any of the form. One of the form is bank guarantee. And it is pursuant to this term, corporate debtor and furnish the bank guarantee. That is at page 190.
Put 190.
This is the bank guarantee which was furnished. Your lordship sees it was the guarantee is dated 18/1/2019.
6 crore 5,62,600.
Yes.
Guarantee amount.
This was the guarantee.
The claim is for this now, essentially.
I am seeking a return of this bank. Now, thereafter, the company, there is the operational credit, there was a creditor of that the corporate debtor. He approaches the NCLT and a proceeding under CIRP is registered. That is at page 144. That your lordships will get at page 140 is the order of the NCLT. At the bottom of that page, your lordships will find that the order was pronounced on the 8th of December 2022. Now, at page 144, paragraph 4.1, the corporate insolvency resolution process was initiated on 10/3/2021.
Yes.
The lordship gets that?
Yes.
And thereafter, over the page, I will not bother your lordship. There is an entire process which, as prescribed under the IBC, is gone through, which is recorded by the NCLT. Entire para 4 is devoted to that. That is, your lordship may not be bothered with that because it has culminated in a final order and which is not being assailed before your lordship. Now your lordship may come to page 175.
Yes.
Para 3.11.5. May I please this?
Asserted.
It is asserted by virtue of the approval of the resolution plan by the adjudicating authority, the resolution applicant shall take over the corporate debtor on a fresh slate. The fresh slate principle has been enunciated by the Honorable Supreme Court in the Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta and others, and further ratified and crystallized by the Honorable Apex Court in Ganesham Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction, wherein the Honorable Supreme Court stated that, quote, a successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted, as this would amount to a hydra head popping up, which would throw into uncertainty amounts payable by a prospective resolution applicant who successfully takes over the business of a corporate debtor. All claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. This is the successful resolution applicant does on a fresh slate, as has been pointed out by us herein above. Quotation ends. Para 3.11.6. Therefore, basis the fresh slate principle, all liabilities of the corporate debtor, that is, erstwhile entity, if any, in any capacity of shareholders of its subsidiaries, joint ventures, associate companies, investee companies, and entities where corporate debtor is a shareholder, including PSA, Sickle Terminus so-and-so mining, shall stand extinguished, settled, abated, and written off with effect from the NCLT approval date by virtue of the order of the NCLT approving this resolution plan, and the resolution applicant or the corporate debtor shall at no point of time be directly or indirectly held responsible or liable in relation thereto. Thereafter, on the next page.
So finality is given.
That is the purpose of this code, my lord. Otherwise, and that is how our corporate structure is sought to be streamlined in India. Because your lordship knows that there was a lot of turbulence in the Erstwhile Companies Act, and huge time was consumed. The Surfacey Act was also found to be inadequate, and that is why the IBC. Now, your lordship will find at page 187, page 20, para 25, in the second one, the tribunal finds that we find that the resolution plan has been approved with 77.55% voting share. Now, kindly come to page 188.
Subject to the
Para 28. Subject to the observations made in this order, the resolution plan is here in question is hereby approved by this adjudicating authority. The resolution plan shall form part of this order. The resolution plan is binding on the corporate debtor and other stakeholders involved so that the revival of the debtor company shall come into force with immediate effect. Now, your lordship may now see what is there in the resolution plan.
That para is?
Resolution, I filed it by way of a memo on 4/2/2026.
Yes.
Your Lordship has that. Kindly take page 43. Page 43. Para 3.2.10.
Of your memo.
Of my memo, that is the resolution plan which has been filed, and the document that is enclosed therewith, your Lordship may take page 43. The entire document is the resolution plan.
Yes.
Now kindly take para 3.2.10 at page 40. At the bottom of that page. Page 43. The page numbers are given at the bottom of the page.
Hey, go to 43. Yeah.
Has found that page?
Yes.
Now kindly take para 3.2.10 at the bottom of that page 43.
Three point
2.10.
of that M1.
3.2.10.
Memo M1, page 43. Memo M1. This is different page. M1, annexure M1. See this. See the page 43. Internal page 43.
Your Lordship, use the hard copy.
It is done. 3.2.
3.2.10.
Next. Yes. No, all right.
Your Lordship has that. Yeah. All liabilities of the corporate debtor in relation to etc., 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 etc. Third line is bank guarantees. All liabilities of the corporate debtor in relation to bank guarantees. I'm leaving out the others. Bank guarantees is in the third line. Now thereafter, your Lordship may also skip over the rest of the
Performance guarantees.
The performance guarantees, etc., etc. Now, last two lines of that page. In respect of any debt or other obligation of the corporate debtor, whether any claims in respect thereof have been admitted in the CIRP or not, along with any other contingent or future claims, liabilities, and or commitments of any nature whatsoever issued by or on behalf of at the behest of the corporate debtor or incurred or undertaken by the corporate debtor as the case may be, till the effective date, whether asserted or unasserted, whether secured or unsecured, dispute or undisputed. Thereafter, your Lordship may skip two lines and then sentence will be and be deemed to be permanently extinguished
Upon payment of the mandatory dissenting financial credit payment.
upfront FC payment so and so on the effective date with effect from the NCLT approval date, and all liabilities of the corporate debtor in relation thereto will be written off in full, subject to payment of the deferred FC debt payment in accordance with the term of the resolution plan. The corporate debtor or the resolution applicant shall at no point of time be directly or indirectly held responsible or liable in relation thereto. Now, thereafter, next, your Lordship may turn to page 48. clause 3.2.23.
Three point
2.3. The financial creditors acknowledge that certain bank guarantees, including those that may get invoked after the commitment of creditors' approval date, including after the effective date, that are listed in Annexure 5 of this resolution plan.
In Annexure 5?
It is there. I'll come to that. Annexure 5 of the resolution plan are necessary or required for maintaining the corporate debtor as a going concern. The respective financial creditors that have issued the bank guarantee that are listed in Annexure 5 shall continue such necessary bank guarantees and continue to renew, extend from time to time, including after the effective date and including till such time the bank guarantees, if being replaced, are replaced by the resolution applicant in accordance with section 3.2.24. Your Lordship may skip that next few lines. Thereafter, Your Lordship takes the sentence beginning
about to constitute financial creditor
will be deemed to be permanently extinguished. Your Lordship, about 10 lines from the bottom of that paragraph, will be deemed to be permanently extinguished upon payment of the mandatory dissenting financial creditors payment upfront, FC debt payment and balance FC debt assignment consideration on the effective date with effect from the
permanently extinguished,
and all liabilities of the corporate debtor and the resolution applicant in relation thereto will be written off in full. The corporate debtor or the resolution applicant shall at no point of time be directly or indirectly held responsible or liable in relation thereto. It is further clarified that subject to the terms above, the bank guarantees or similar such contingent liabilities that are invoked and crystallized after the COC approval date, the NCLT approval date, and or the effective date shall be deemed to constitute financial creditors' debt for the purpose of the resolution plan and shall be treated as part of the FC consideration and shall be accorded such treatment as is proposed in subsection 3.2, etc., without any increase in the FC debt consideration at any point of time. Next, on the next page, Schedule B bank guarantees, Your Lordship finds. This is a Schedule B bank guarantee. That's why I'm taking Your Lordship directly to Schedule B bank guarantees. Paragraph D, Your Lordship, miss.
C is also
yes.
Your Lordship takes paragraph D. Schedule B bank guarantees, paragraph D.
Only
in the event the Schedule B bank guarantees are invoked after the effective date, the corporate debtor shall, within 180 days of such invocation, reimburse to the relevant bank in case of invocation of Schedule B bank guarantees to the extent of the aggregate of 50% of such invoked Schedule B bank guarantees amount, and that the issuer bank has paid in accordance with the terms and conditions of such Schedule B bank guarantee issued in favor of the corporate debtor. In relation to the extension of Schedule B bank guarantees, the corporate debtor shall pay bank guarantee commission charges as applicable. So 180 days from the date of approval, it could have been invoked, and in which event 50% liable, to the extent of 50%, the liability would have been there on the corporate debtor. Not on me, but on the corporate debtor.
May I only just point out, it is 180 days from the revocation, not from the approval of resolution plan. Your Lordship may see 180 days from such invocation. So when I invoke the bank guarantee, this 180 day will commence, not from the date the resolution plan is approved. My Lord, I will pause here, my Lord, my learned, because it's a factually it might have been.
He will interpret it in his own way. Let me.
No, what is your answer to this query?
I'll come to that. I'll show what is the date on which the contract started, what is the date on which it was ended, till date. Till date, as we stand today, speak today here, Manas, before Your Lordship, the bank guarantees have not been invoked.
So you may take a decision not to invoke also. Is it your submission?
No, my lord, because my learned senior is addressing the court.
No, we have understood.
Yes.
It is, see, such invoked 50% of such invoked scheduled B guarantee amount.
My lord, may read C also.
Case of invocation of such scheduled B guarantee invocation will be by you only.
Yes, my lord. I will invoke, bank will pay me. I have a bank guarantee of 6 crores.
Yeah.
If I invoke, they will give me 6 crores.
Correct.
Say, suppose I say I have a liability of, say, against him, I have a liability of 1 crore.
Yeah.
5 crores shall be returned to the bank.
Yeah.
So what happens, my lord? This 1 crore, what I understand from this, 1 crore, 50% shall be borne by the current petitioner or the corporate debtor. So that's the plan. My lord, I have something. My learned senior made a submission that the security, the bank guarantee shall stand extinguished. On the other page, my learned senior was making some submission. Yes, my lord. May I take your lordship to that page? May I take your lordship to that page? 43.
Well,
there is something.
Submission that
There is something.
what happens?
Yes,
That's what I wanted to listen very well.
Let me complete my submissions. He can have his say. He can have his own interpretation.
My
to
lord,
this.
my lord,
That is why I'm seeking the court's permission to complete my submission.
Yeah.
Um,
No, I wanted some clarification. I wanted.
My lord has to read C also along with the D.
We'll see that. My idea of invocation of bank guarantee, that is limited because beyond the chitty on contracts, I have not read much. So, can you say that I will not invoke the bank guarantee at all? Because the liability is contingent.
Yes, my lord.
How long this contingency can go?
My lord, that
To defeat his interest, you may say, I will not invoke the bank guarantee at all.
No.
Can you go to that extent?
No, that's not my submission at all, my lord. In fact, I have not invoked that because he has been extending it and he is not accept because the matter is sub judice. He has made a claim that the bank guarantee, the liability arising out of the bank guarantee seems to have been extinguished by operation of the resolution plan and the approval of the resolution plan by the Hon'Ble. Yes, my lord.
Just keep this in your.
Yes, my lord. I am conscious.
Yeah.
Now let's. Your lordship may straightway come to schedule B, page 115. Moderator here. Either you go really the way I am going, or you jump for.
Yes.
Your lordship finds at page 115, schedule B, because there was a reference to schedule B that these are the bank guarantees which are in force. May I read that portion now?
Yeah, well, it's obvious.
These are the bank guarantees which are in force, and what are the liabilities in respect of the bank guarantees have also been spelled out in to what extent the bank liabilities will be extended, and when and on which date they will stand frozen. Now, my lords, your lordship sees at schedule B the top entry. The first entry is the bank guarantee in question.
All the bank guarantees.
Now, only the top one, the one, the first entry, that is PG 5191 GPER 219.
Which page you are referring
to? Page 115, my lords. That is the schedule B.
Schedule B.
Yes, ma'am. The first entry.
0519 IGPER 000219.
Yes, that is the bank guarantee which I had shown to your lordship. And that is the schedule B. That amount also matches 6 crores, 5 lakhs, 5,600. Now, my lords, what are the assets which have come into my hands? Kindly come back to page 113. Serial number 2 at that page, proposal of asset acquisition.
Yes.
A. Details of the assets proposed to be purchased, taken over, transferred, and or proposed transaction structure. Please see Section 4, acquisition of Part B of financial proposal of the resolution plan. Then thereafter, 1, 2, 3, 4, your lordship may summary key commitments. Next page, serial number 3. Summary 3 key commitments, serial number 8.
8, bank guarantee.
Necessary bank guarantees as dealt in subsection 3.2.23,
3.2.24
of Part B financial proposal. I have also already shown to your lordship 3.2.23 and 3.2.24. I have also shown to your lordship Part B.
Yes.
And 3.2.23 and 3.2.24 spell out.
There is a heading to that, my lord may see. That's a summary key commitment. That's not what it runs from to. So these are the commitments under the plan, my lord. It's not the asset. Your lordship may see the heading, the same page.
Summary key commitments.
These are key commitments, not the assets. Your lordship may see the other page was for proposal for asset acquisition. My lord, just the earlier page 110.
Correct.
That was proposal for asset acquisition. It ends with para 4 IV.
Correct.
Then para 3 or the clause 3 is summary key commitments. So this is the commitment under the plan. It's not the asset. So this necessary bank guarantee, my submission would be or cannot be. Yes, ma'am.
Anyway, this also you keep in your head. We may ask at appropriate time.
Yes, ma'am.
So, my lords, now let me again come back to, because there is no dispute as far as the entry on the right-hand side value is concerned, as dealt with in subsection 3.2.23 and 3.2.24. I will again request your lordship, for my own satisfaction, to kindly go back to 3.2.23 and 3.2.4. So that for clarity, till what extent the liability would whether the liability is still there or it stands extinguished. The financial creditors, 3.2.23, that is at page 48.
3.2.23.
That is the one which was referred.
Yes, twice.
The financial creditors, the financial creditor is a bank.
Correct.
Acknowledge that certain bank guarantees, including those that may get invoked after COC approval date, including after the effective date, that are listed in Annexure 5 of this resolution plan, are necessary or required for maintaining of the corporate debtor as a going concern. The respective financial creditors that have issued the bank guarantee are listed in Annexure 5, shall continue such necessary bank guarantee and continue to renew, extend such bank guarantee till such time as may be required by the corporate debtor from time to time, including after the effective date and including such time that the bank guarantees, if being replaced, are replaced by the resolution applicant in accordance with Section 3.2.24. For avoidance of any doubt, it is clarified that other than the bank guarantees that are listed in Annexure, we are not concerned. Your Lordship may skip over a few lines, take the sentence. Let me read the entire thing.
No,
let me read the entire thing. For avoidance of any doubt, it is clarified that other than the bank guarantees that are listed in Annexure 5, all liabilities of the corporate debtor in relation to any bank guarantees, whether any claims in respect thereof have been admitted in the CIRP or not, along with other contingent or future claims, liabilities and or commitments of any nature whatsoever issued by or on behalf of or at the behest of the corporate debtor or incurred or undertaken by the corporate debtor as the case may be, till the effective date, whether asserted or unasserted, whether claimed or not, whether admitted or not, crystallized or uncrystallized, known or unknown, secured or unsecured, disputed or undisputed, whether or not set out in the information memorandum, the virtual data room, the balance sheet of the corporate debtor, or the profit and loss account of the corporate debtor will be and be deemed to be permanently extinguished upon payment of the mandatory dissenting financial creditor payment, upfront FC debt payment, and balance FC debt assignment consideration on the effective date with effect from the NCLT approval date. And all liabilities of the corporate debtor and the resolution applicant in relation thereto will be written off in full. The corporate debtor or the resolution applicant shall at no point of time be directly or indirectly held responsible or liable in relation thereto. It is further clarified that subject to the terms above, the bank guarantees or similar such contingent liabilities that are invoked and crystallized after the COC approval date, the NCLT approval date, and the effective date shall be deemed to constitute financial creditor debt for the purpose of the resolution plan and shall be treated as part of the FC debt consideration and shall be accorded such treatment as is proposed in subsection 3.2 together with subsection 1.2.7 part B of the financial proposal and the resolution plan without any increase in the FC debt consideration at any point of time.
3.2.24 you read.
3.2. Notwithstanding anything to the contrary contained in the resolution plan and stated above under section 3.2.23, all liabilities of the corporate debtor in relation to the necessary bank guarantees as listed in Schedule A, B, C, and D of Annexure 5 shall be dealt with in the following manner. Yes. All the bank guarantees provided in Schedule A of Annexure 5 shall be constituted to be renewed, extended by the respective banks, including such time till the bank guarantees, if being replaced, are replaced by the corporate debtors in section 3.7. So we are not concerned. We are not in Schedule A. We are in Schedule B.
B. Okay.
Schedule B bank guarantee is the next year. Let me read out the entire thing. All the bank guarantees provided in Schedule B of Annexure 5 shall continue to be renewed, extended by the respective bank till the time as may be required by the corporate debtor, including after the effective date.
Mr. Mukherjee, whether just we want to know whether bank also will participate in the IBC process?
Yes, absolutely.
Okay.
They
cannot do all this. Yes.
They are the financial creditors. They are part and parcel of the IBC proceeding. Then D, only in the event of Schedule B bank guarantees are invoked after effective date, the corporate debtor shall within 180 days from such invocation reimburse to the relevant bank in case of invocation of such Schedule B bank guarantees to the extent of aggregate of 50% of such invoked Schedule B bank guarantees amount that the issuer bank has paid in accordance with the terms and conditions of Schedule B bank guarantee issued in favor of corporate debtor. In relation to the extension of Schedule B bank guarantees, the corporate debtor shall pay bank guarantee commission charges as applicable.
Yeah.
So this is the resolution plan, the relevant portion of which I have placed before your lordship, and I have also indicated to your lordship at what point of time the liabilities stand extinguished. Now, my lords, your lordship may kindly see the approval order. The claim of put forth by the MCL in the counter affidavit. And actually, anybody
My lord must deposit at least 1,000 rupees to the bank. At least.
Secretary will be.
At least.
Sometimes it happens. Now, suppose in one matter, I was sitting in the court hall.
Right.
The phone of a gentleman from the village rang. Then the Honorable Chief Justice was a bit angry. It's happened in Karnataka. And when he was speaking to him, showing red eye, his own phone started. Happens sometimes. Unless it disturbs this kind of music. It's a music to the ear. It's not that your submission is the submission at the bar is boredom, but some sound. You can see that way also. Nobody intentionally does.
My lord, I am for the.
You are. We know that. You want to increase the size of your purse.
Yes.
The purse of the bar.
Yes, madam.
Let us. If it again rings, then perhaps that person will have to pay. Anyway, yes.
I was inviting your lordship's attention to annexure A/2 at page 10 of the counter. There's a counter filed by the Manadi Court.
Go to counters. Approval order.
Yes, ma'am. Approval order.
Yes.
Now, the second paragraph thereof is important.
After
receiving the proposal from the project so and so for approval of shortfall penalty of amounting to rupees 1 crore 62 lakhs, etc., only of Sikal Logistics for the period. Kindly see, the period is very important.
2018.
30/12/2018 to 31/3/22, including time extension period, the area shortfall penalty committee checked the penalty calculated by the project and found to be correct, which has been agreed by the area finance manager, imbue area. This is, kindly see the date. This is 6/4/2023. This is after the date on which the NCLT approved the plan, that is on 8th of December 2022.
Yes.
Now, my lords, kindly see section 31 of the code.
Yes. I miss. Yes, face it.
Section 30.
Well,
Adjudicating authority is satisfied that the resolution plan as approved by the Committee of Creditors under subsection 4, section 13, meets the requirement as referred to in subsection 2 of section 13. It shall by order approve the resolution plan, which shall be binding on the corporate debtor and its employees, members, creditors, including the central government, any state government, or any local authority to whom a debt in respect of payment of dues arising under any law for the timing in force, such as authorities to whom statutory dues are owed, guarantors, and other stakeholders involved in the resolution plan, provided that the adjudicating authority shall, before passing an order for approval of the resolution plan under the subsection,
they should be heard in the matter.
Sir.
They should be heard in the matter. Otherwise, they will not be able to.
Okay. So after, now there is no, I don't think my learned friend will quarrel with the proposition that the MCL is at worst a local authority and a state under Article 12. And it's
local authority is different.
No.
Local authority is defined under the general
But central government and its agencies, it comes within that. It's a central government undertaking. Mahanadi Coalfield is a subsidiary of the Coal India Limited.
But Article 12 is not used there.
Article 12 is not, the spirit of Article 12 is
Article 12. They will come under Article 12.
No, but section.
Well, what it says is
the idea of Article 12.
Including central government, including, it's a
inclusive definition.
Including the central government, any state government or any local authority to whom a debt in respect of payment of dues arising under any law for the timing in force, such as authorities to whom statutory dues are owed, guarantors and other stakeholders involved in the resolution plan. So, my lords, my humble submission subject to your lordship is that the MCL squarely falls within this category of persons defined under section 31. And once the resolution plan is approved in November 2022, it is no longer open for them to subsequently come up in April 2023 and say that we have something receivable. Now kindly see Ghanshyam Mishra, my lords. Let me show to your lordship what law has been laid down here, my lords.
Justice Nariman's judgment. Justice Nariman's judgment. Ghanshyam is by whom?
This is Ghanshyam Mishra is. Judgment has been penned by Justice Gawai. kindly take paragraph 86. It is at page 26 of that plan. Page 36 is the plan. It's flag one. Para 86.
As discussed.
As discussed here and above, one of the principal objects of INB code is providing for revival of a corporate debtor and make it a going concern. The Insolvency and Bankruptcy Code is a complete code in itself. Upon admission of a petition under Section 7, there are various important duties and functions entrusted to the resolution professional and the committee of creditors. Resolution professional is required to issue a publication inviting claims from all stakeholders. He is required to collate said information and submit necessary details in the information memorandum. The resolution applicant submits their plan on the basis of the details provided in the information memorandum. The resolution plan undergo deep scrutiny by the resolution professional as well as the committee of creditors. In the negotiations that may be held between the committee of creditors and the resolution applicant, various modifications may be made so as to ensure that while paying part of the dues of the financial creditors as well as operational creditors and other stakeholders, the corporate debtor is revived and made an ongoing concern. After corporate creditors approves the plan, the adjudicating authority is required to arrive at a subjective satisfaction that the plan conforms to the requirement as are provided in subsection 2 of section 30 of the code. Only thereafter, the adjudicating authority can grant its approval to the plan. It is at this stage that the plan becomes binding on corporate debtors, its employees, creditors, guarantors, and other stakeholders involved in the resolution plan. The legislative intent behind this is to freeze all claims so that the resolution applicant starts on a clean slate and is not rung with any surprise claims. If that is permitted, the very calculation on the basis of which a resolution applicant submits its plan would go haywire and the plan would be unworkable. Next para 87. We have no hesitation to say that the word other stakeholders would squarely cover the central government, any state government, or any local authority. The legislature noticing that on account of obvious omission, certain tax authorities were not abiding by the mandate of the INB code and continuing with the proceeding has brought out the 2019 amendment so as to cure the said mischief. We therefore hold that the 2019 amendment is declaratory and clarifying in nature and therefore retrospective in operation. So income tax, indirect tax, everything. Now kindly take the conclusion at page next page, para 95. In the result,
we answer.
In the result, we answer the questions framed by us as under. 1. That once a resolution plan is duly approved by the adjudicating authority as a subsection 1 of section 31, the claims as provided in the resolution plan shall stand frozen and will be binding on the corporate debtor and its employees, members, creditors, including the central government, any
state government
or local authority, guarantors, and other stakeholders. On the date of approval of the resolution plan by the adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished, and no person will be entitled to initiate or continue any proceeding in respect of a claim which is not part of the resolution plan. 2. 2019 amendment to section 31 of the INB code is clarificatory and declaratory in nature, therefore will be effective from the date on which the INB code has come into effect. 3. Consequently, all the dues, including the statutory dues owed to the central government, any state government, or any local authority, if not part of the resolution plan, shall stand extinguished, and no proceeding in respect of such dues for the period prior to the date on which the adjudicating authority grants it approval under section 31 would be continued.
So it's a complete protective umbrella.
Yes, that is exactly. Now, my lords, Justice Nariman's judgment, that is SR Steel Limited versus Satish Kumar Gupta.
Any view is there? No.
No, not to mine. But this is being reiterated time and again, time and again. Now your lordship takes the other judgment of Justice Nariman, which is penned by your lordship was referring to this. This is still limited.
No, I was referring to Ghanshyam. I was under wrong impression that it was Justice Nariman who had authored.
But that Hydra had
part of the bench.
He was part of the bench. Now, my lord, his language is here, my lord. That Hydra head thing. Para 67. Para 67. This is prior to Ghanshyam. Para 67, your lordship.
67 of
this Satish Gupta. SR Steel versus Satish Gupta. 67 is at page 57. I have flagged it. Where your lordship let me find. May I read it, my lord?
Yes, sir.
For the same reason, the impugned enclave judgment.
Paragraph
67.
67.
For the same reason, the impugned enclave judgment in holding that the claims that may exist apart from those decided on merits by the resolution professional and by the adjudicating authority appellate tribunal can now be decided by an appropriate forum in terms of section 60 subsection 6 of the code also militates against the rationale of section 31 of the code. A successful resolution applicant cannot suddenly be faced with undecided claims after the resolution plan submitted by him has been accepted, and this would amount to a Hydra head popping up, which would throw into uncertainty amounts payable by a prospective resolution applicant who successfully takes over the business of a corporate debtor. All claims must be submitted to and decided by the resolution professional so that a prospective resolution applicant knows exactly what has to be paid in order that it may then take over and run the business of the corporate debtor. This the successful resolution applicant does on a fresh slate, as has been pointed out by us herein above. For this reason, the enclave judgment must be set aside on this count. Now, my lords, just one more provision I will show to your lordship. Now, here, my lords, I will submit that after the resolution plan is approved in November 2022, in December 2022, by the NCLT, the claim that is proposed to be put forth by the MCL in April 2023 or in April 2023 is a Hydra head popping up, which I cannot be faced with. One more provision I will show to your lordship, that's section 61 of the code.
Make repetition.
Repetition of
the last
matter. But my submission is in December 2022, the NCLT approved the resolution plan. It received the final extent of the under section 31.
End of the matter.
End of the matter.
Subsequently, no Hydra head can pop up.
And in April 2023, they approve a claim. What is being put forth in the counter before your lordship? In April 2023,
in other words, the stand
of MCL.
Resisting this militates against what is stated in para 67.
That is my submission to your lordship. Now, my lords, whatever has been done under section 31, it's not that there is no remedy to it. Section 61 of the code provides for the remedy.
What it says?
Appeals and appeals. So,
to the NCLAT.
Right. So that is the only remedy that is available. If that has not been availed of or is not being availed of,
it's concluded.
It is conclusive. It cannot, no suit will lie, no other proceeding would lie. It stands crystallized.
Any barring section is there?
Proceed, other proceeding, yes.
Bar of suit, etc.
Yes. Section
Then-
63. No civil court or authority shall have jurisdiction to entertain any suit or proceeding in respect of any matter in which the NCLT or the appellate authority has jurisdiction under this code. Civil court not to have any jurisdiction. And thereafter, section 238. Provisions of this code to override other laws. The provision of this code shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being imposed or any other instrument having effect by virtue of such law.
Yes.
Now, the only reason why I have kept the bank guarantee alive is Annexure 15, where I was called upon by the Mahanadi Coalfields to extend the bank guarantee.
Yes.
So it is only for that reason and
Your argument is over.
that is all. That is all.
We'll come back. Change of law as on today.
As on today, the latest position, Manoj,
Any
One
latest judgment which reiterates this position?
goes on and on. That is Kalyani Transco versus Bhushan Power and Steel.
Bhushan.
This.
It reiterates. Perhaps there is some reiteration, I believe.
Absolutely. Here also, they say.
Lord, in fact, this is the legal position as on date to my knowledge, my lord. That even I also ventured to find out.
Only with that thing of personal guarantee, my lord, some changes has taken place. But otherwise.
Yeah. Now we will argue now.
Yes.
Yeah.
Now, my lord, before I get into replying to the submissions of my learned senior, my lord, in the present form, my lord, the writ application, the prayer is to release bank guarantee. That's the only prayer now after abandonment of prayer 2. So, my lord, bank guarantee arising out of a contract, my lord, the writ application per se may not be maintainable, my lord, being for two reasons, being a purely contractual dispute and, my lord, for the reason that.
But where is the dispute?
No, my lord, because if now what my learned senior relied upon my document filed in my counter, that there is a liability that has not been challenged here. My lord, that document where I say that there is a liability or there is some recoverable, that has not been.
Not that. You want him to go to suit.
No, I'm not saying I cannot advise him, my lord.
You are arguing that way.
Yes, my submission is that at the outset, the rate may not be maintainable. Because first, my lord, for refund of bank guarantee, return.
No, where are the disputed facts?
Disputed facts, my lord, I say that the bank guarantee is an independent contract with the bank.
That we cannot judge.
My lord,
that we see.
Yes.
When we relegate
that's my submission,
alternate remedies, the facts are disputed.
Yes, my lord.
As usually they will be.
Yes, my lord.
And that dispute cannot be adjudged by the writ court based upon the material on record.
My lord.
If these two conditions are complied, wait, we have to send him to the other forum.
My lord.
Suppose if facts always will be disputed,
My lord.
but if those disputed facts can be ascertained
My lord.
from the material on record,
My lord.
then we will not send him back.
No, my lord. And there is no absolute bar I can have.
That's what.
Yes, my lord.
After all, it's not a bar of jurisdiction.
Yes,
at
yes.
all.
No, but
It's an
there is no
alternative
absolute
remedy.
Yes, yes. My
That-
lord, that is. Now, my lord, with regards to the judgment in the of the Honorable Appeals Court in Ghanshyam Mishra, my lord, my submission at the threshold is the all liabilities shall stand extinguished except what has been provided for in the resolution plan.
Correct.
So, my lord, what is provided for in the resolution plan,
That is retained.
that is retained, man. So, my lord, may I take your lordship to page 103, wherein that total of the performance security and retention money should not exceed 10% of annualized value. The refund of security deposit shall be subject to company's right to deduct appropriate its dues against the contractor under the contract or any other contract on completion of the work and certified as such by the engineer in charge. The security deposit remaining with the contract shall be refunded. Now, my lord, may I take your lordship to page 177, which is the approval of the resolution plan.
177.
Yes, please.
Of memo.
No, my lord. 177 of the writ application. I'm sorry.
Writ application.
Yes.
Where is that?
177 of the writ application.
See that which paragraph page he is referring to. This is the page. 177.
7. Para 18.
We don't find that. We are not on the same page. Maybe.
It is writ application number 11891 of 2024.
That MCL G2 so and so. Annexer 15 you are speaking.
My lord, I am referring to the annexer in writ application 11891 of 2024. I think that's the other writ application which are also placed.
There are two writ petitions.
Yes, my lord.
One by Patnaik and one by Mr. Mukherjee.
Yes. My learned senior made a submission with regards to 11891.
That's what. Paragraph 18.
My lord.
In relation to.
In relation to the acquisition of the corporate debtor as a going concern, Section 4 of Part B of the resolution plan states as follows. I take your lordship to step 2. Assignment of balance FC debt and admitted other operational creditor debt. Balance FC debt. Now, my lord, what is that balance FC debt? I will take your lordship there, my lord. Now, my lord.
No, that is heading you have read.
No, my lord. Why I will take your lordship to the what is the debt and the balance FC debt. So that's why I just referred there. Now, my lord, may I take your lordship to that memo?
M1.
Yes, my lord. May I take your
flag 20.
My lord, that
resolution plan.
Yes, my lord. Now, my lord, page 48. My lord, go to page 48. Para 3.2.23.
Correct. Which Mr. Mukherjee had read.
Yes, my lord. My lord, towards the middle, for avoidance of any doubt, my lord, just 10th line, my lord.
From below or above?
No, above. 10th line from the first line of 3.2.23. For avoidance of any doubt.
For avoidance of any doubt.
My lord,
Mhm.
it is clarified that other than the bank guarantees that are listed in Annexure 5 and dealt under Section 3.24. So other than what has been there, it will be extinguished. That last line where my learned senior said permanently extinguished, my lord, towards 6 lines below, it starts with other than the bank guarantees that are listed in Annexure 5. So it will be extinguished except Annexure 5. My lord, may I otherwise read the
Other
entire-
than the bank guarantees that are listed in Annexure 5.
Yes.
So
So
will not be.
the other things will be extinguished, but this Annexure 5, whichever bank guarantees
That
are there,
remains intact.
that remains intact. My lord, if your lordship wants, I can read the entire paragraph.
Let us read that.
Yes, sir. For avoidance of any doubt, it is clarified that other than the bank guarantees that are listed in Annexure 5, necessary bank guarantees, and dealt under the Section 3.2.24 below, all liabilities of the corporate debtor in relation to any bank guarantees, whether any claims in respect thereof
Are extinguished.
Yes, whether, but again, whether any claim in respect thereof have been admitted in CIRP or not. So with regards to Annexure 5 bank guarantees, even if it has been
Whether raised or not.
even raised or not, admitted or not, is immaterial. My lord, what it has, the plan provides for an exception in regards to some bank guarantees. The purpose was, my lord, that to keep this is not a defunct unit, my lord, because going concern. So there are some ongoing live contracts which are being performed during that during the CIRP period also, my lord. Now, my lord, the reason why those bank guarantees, the RP also provides, the resolution plan also provides that some bank guarantees have to be kept on being extended. The reason is so that those liabilities or assets, whatever would arise therefrom, how that will be dealt with is also provided. Again, my lord, may I take, I read 3.2.24 again, notwithstanding
Is
any.
it, one second, brother. Is it Annexure 5 guarantees?
Yes, my lord. Yes, he has shown your lordship that. I will
Mr.
show also.
Mukherjee admits that it's a 5 guarantee. Yes, Annexure 5 guarantee.
Yes, it's there, my lord.
It's listed in Annexure
Yes.
5 itself.
Your lordship may say, I'll show the page. Page number 114.
Annexure 5, Schedule B.
Schedule B. So
Schedule B of Annexure 5.
Okay.
My lord. Now, my lord, 3.2.24. That the same, so page 48 last. Page 48.
Yes, sir.
Notwithstanding anything to the contrary contained in the resolution plan, so again an exception, and stated above under section 3.2.23, all liabilities. So here again an exception is carved out in respect of liabilities which may arise out of the bank guarantees provided under Annexure 5, my lord. So, my lord, what is to be seen, my lord, that there is a exception which has been carved out in respect of the subject bank guarantee, which is enlisted under Annexure 5, Schedule B. Now, my lord, may I take your lordship to page 49, the next page. What is the Schedule B bank guarantee? D. Only in the event the Schedule B bank guarantees are invoked after effective date, the corporate debtor shall, within 180 days from such invocation. I stop here for a moment, my lord. Whenever it is after the effective date, so effective days is provided under the approval order, resolution itself and the approval order. So, my lord, this eventuality will only come after the approval of resolution plan. So, it's a future date.
It has to be that.
Yes, my lord. So, my lord, within 180 days from such invocation, reimburse to the relevant bank in case of invocation of such Schedule B bank guarantee to the extent of aggregate of 50% of such invoked Schedule B bank guarantee. I stop here for a moment again. Now, my lord, consciously the resolution plan provides, taking into the ongoing concern and the which involve this decision-making process involve the financial creditors, the banks and everybody. They say that what he will be liable for is 50%. Say, suppose, my lord, I think that 2 crore rupees invoked. 2 crore rupees has to be given to MCL. Now, my lord,
1 crore.
1 crore is to be borne by the prospective resolution applicant, who is now the corporate debtor. So, because after approval of his plan being selected out of the other prospective resolution applicants, now he has become the corporate debtor after approval of the resolution plan. So now it's the resolution corporate debtor which is the petitioner.
Because he stands on the shoes of
Yes.
corporate debtor.
Yes, ma'am. So, my lord, I read a little more than that. Of such invokes, it will be bank guarantee amount that the issuer bank had paid in accordance with terms and conditions of such schedule B bank guarantee. Independent contract, my lord. A bank guarantee has an independent contract, my lord. Once I invoke, bank is required to pay to me that amount without even asking anything. So, my lord, issued in favor of the corporate debtor in relation to the extension of schedule B bank guarantee, the corporate debtor shall pay bank guarantee commission. So what, my lord, this provides, my submission is that he will have to renew, because the plan provides for that there may be cases where it may be required to renew the bank guarantee. So, my lord, that renewal is also provided for, and in that case, he will have to bear the full
so in other words, it is a contemplated liability.
Yes, contingent liability or a contemplated liability. So, my lord, again, may I take your lordship to page 111. And just before that, I take your lordship to 110. Just one line from 110, my lord. Propose, your lordship, 110. Yeah. Yes, of the memo.
The memo.
Yes, my lord. The same document, that resolution plan itself. The same document which your lordship. Page 110. That is para 2, clause 2 is proposal for asset acquisition.
Correct.
That ends here on the same page. The next page, 110.
Summary key commitments.
My lord, the next page is summary key commitments. So that 2 and 3 are totally different. So it's not asset acquisition proposal, my lord. Proposal for asset acquisition. So, my lord, that is different and this is different. This cannot be an asset. A bank guarantee, my submission would be that a bank guarantee cannot be an asset because there is no funds which is available. Say, suppose I don't invoke the bank guarantee and I refund it to him, he is not going to get the 6 crores. There is just an exposure bank has taken. There is a margin money which has been paid by him. So it cannot come back to him, my lord. That entire 6 crores is not made available by the erstwhile corporate debtor.
So it is not an asset at all.
It cannot be an asset at all, is my submission, man.
How courts have treated this question?
But that I'll have, may I just complete with my commission?
No, just we wanted to.
Yes, no, I have not.
I do not have much exposure to this branch of law. Therefore, I asked.
My lord,
any court has answered this question?
My lord, I'll have to, because I am not readily available. My lord, then, may I take your lordship to page 114 running into page 115, 114 of the same resolution plan, my lord. My lord, it is Annexer 5, Schedule A, then next page 115, Schedule B.
Correct.
My lord, the very first bank guarantee is the subject bank guarantee, my lord.
Correct. 0519 IGPER 000219.
Yes.
6 crore 5,62,600.
Okay. So, my lord, my submission is, in view of what has been provided for in the resolution plan, even if the liabilities which were not raised, not admitted, have been kept secure, which are related to this bank guarantee.
Please repeat.
My lord, in view of the submissions made by me, my lord, with referring to what has been provided for under the column necessary bank guarantees, which is Annexure 5, for necessary bank guarantees, there are some, that it is specifically provided that any liability arising therefrom, even if not raised or not admitted, if you
Therefore, it will not be a hydra head at all.
it will not be hydra head at all. My lord, may I take your lordship again to that?
2.3.2.
Yes, my lord. 2.3.24. Yes, my lord. Notwithstanding
3.2.2.
Yes, sir. For avoidance of any doubt, it is clarified that other than the bank guarantees that are listed in Annexure 5.
So this fits into an other than only.
Yes, my lord. No.
Exception is made.
No.
Huh?
Necessary bank, for avoidance of any doubt, it is clarified that other than the bank guarantees that are listed in Annexure 5.
Yeah.
So
it is in Annexure 5 only.
Yes. So all what is being discussed thereafter,
they are extinguished.
Except this. Except Annexure 5. So I'll just emphasize on another word. Are listed in Annexure 5 and dealt under section 3.2.24 below. All liabilities of the corporate debtor in relation to any bank guarantee except the Annexure 5, whether any claims in respect thereof have been admitted in CIRP or not, along with any other contingent or further claims, liabilities, and so all these are in respect of bank guarantees which do not form a part of Annexure 5, Schedule A, B or C. Schedule A, say, my lord, I'll just bring it to your lordship. Schedule A is there where 100% liability will pass on to the corporate debtor. Your lordship,
B is 50%.
B is 50%. So, my lord, even if that 50% has to be saddled on him, because say I ask a question to myself, my lord, say suppose MCL chooses to invoke the bank guarantee now suppose he chooses to not renew the bank guarantee, or he doesn't own up his liability. Now I invoke the bank guarantee. So bank has to pay me the money. So I get the money. My money is secured. So bank has to then reimburse get it reimbursed from the corporate debtor. So that is provided for in the plan. So this cannot be said to be a hydra head. That Ghanshyam Mishra judgment of the Honorable Apex Court, section 31 of the IBC, all these rather protects me, man. Because the resolution plan itself provides for that.
Yes.
So my submission is that bank guarantee, it's a contractual liability, my lord. He has to approach the MCL. MCL has to, my lord, see, there is a closure of contract which has to be effected, which has not been effected as yet because of the, my lord, he has several litigations were going on. And at the present writ application where he says that the bank guarantee has to be refunded as it is to him. So, my lord, that he has to approach the MCL for a closure of contract because he has stepped into the shoes of the corporate debtor. So now my contractor is still there. MCL is an employer. Now, my lord, contractor, he still continues.
He stands in the shoes of
the relevant. My lord, this sentence is very relevant that the contractor continues.
My lord, he is again a contractor against me. So there has to be a closure of contract which has to be effected, my lord, for refund, if any, to the, my lord, the corporate debtor or the petitioner. So my lord, my submission is that the writ application does not deserve to be allowed, my lord.
How you have structured your counter?
Counter affidavit, my lord, we have said the counter affidavit, we have said that clause 6.2 provides for performance, how he is to perform, and shortfall penalty has to be deducted. And on clause 6.2 specifically provides for that. My lord, I'll read 2 lines. In the event of contractor's failure to comply with the required progress in terms of the agreed time and progress chart, or to complete the work and clear the site or before the date of completion of contract or extended date of completion, he shall, without prejudice to any other right or remedy available to law, company on account of such breach shall become liable to pay for penalty as under. So, my lord, on this basis, there is some penalty which is to be recovered from the corporate debtor, the contractor, my lord. Now the contractor is the corporate debtor or the petitioner before your lordship, my lord. So, my lord, that has to be, he has to be sent back to MCL. The engineer in charge is under the contract is the person who's to deal with this, my lord. Closure of contract, whatever.
That's your stand.
Yes, ma'am.
Understood. What do you say?
My lord, first, my lord, I want to clear this thing that the resolution plan, my lord.
No, who are you? First,
Yes, ma'am. First, my lord, I am the subcontractor.
Subcontractor
Under
of
the corporate
corporate
debtor.
debtor.
Corporate debtor who is the present now, who has the
My
present.
lord, I have not permitted.
No, no, that now, my lord,
this
again, my lord, let me, if I have started, then let me.
No, my lord, I can just point out, my lord, subcontractor has to be permitted by.
No,
you
no.
don't have a case.
Case, you cannot say that.
Because my lord, MCL is not privy to any contract between, they subcontract between them.
These two have nothing.
No, nothing to, and the
Privity of
contract
contract.
No,
provides.
my lord, he is privy to everything.
No, contract provides. I'm sorry.
My lord,
You
if
are
I am not
secretary.
able to submit my case,
No, that's all right. You are a secretary. Many people will be following you.
my lord,
I'm sorry.
You have not, your case is there is no privity of contract.
No privity of contract, that the contract rather provides that if he is to subcontract to somebody, he is
Take
to seek
approval, your
approval.
approval.
That approval I have not given.
No, my lord.
It's not in my knowledge.
my lord, that is
You will
not.
argue it after here.
Yes, no,
Yes.
because subcontract was.
My lord, because that is my case.
Ah.
My lord, now, first, my lord, how I came before this honorable court, my lord, let me bring that order before this court. 14/3/2024, my
Now,
lord.
what's your prayer?
My prayer is this, that MCL has to pay my bill that I have worked on behalf of the contractor, my lord. That is my prayer. Why I am saying so, my lord? First, my lord, let me bring the first picture, my lord. First, the order itself, which was passed on 10/3/2024, where there was a direction that your representation pending before MCL has to be decided. Now, MCL rejected my prayer, saying that you are not a subcontractor. I have never allowed you. Now, my lord, first let me place the entire structure of the case, my lord, my case. In 2018, my lord, when the corporate debtor, my lord, entered into an agreement with the MCL after getting selected in the tender process, he was awarded with the work of extraction and transportation of coal, my lord, in MCL area. Now, my lord, he entered into two contracts, that is a subcontract with me, saying that all the NITs and other conditions of the NITs will be followed by you. So I started working since 2018 till August 2020, my lord. And that time, my lord, all this entire work under that 22% of work, whatever he is saying, was executed by the subcontractor under those two contracts, my lord.
But how can you proceed against them in the absence of brevity of contract?
My lord, kindly see. There is a letter where, my lord, I'm coming I'll show those letters, my lord. There was a letter to the MCL by the corporate debtor that you please allow him to work as a subcontractor, and you also, as he has worked, so 90% of the bill has to be deposited in his account. And MCL has received that letter, my lord.
But have they agreed with that?
No, they didn't agree. They kept quiet.
Yeah.
They never stated. They always accepted my executing the work over there. They have never denied that you have not worked over there. Only they are denying that you are not a subcontractor or employed under us.
Because under their terms, unless subcontract is approved by them,
My lord,
you have
my lord. That's what I'm coming into.
there's nothing.
My lord.
There is nothing because it's
No.
the first principle of law of contract.
No, first principle, my lord, I take a departure from that. Why, my lord? While I was working, my lord, they have never objected. And they cannot say that the corporate debtor was working. Corporate debtor was working through a subcontractor. They cannot deny so. They only say that permission part. that I have not given the permission. At what stage, my lord? After the work was completed. After that work was done, my lord. That time they came and say that, no, I have not given you the permission. By silence.
The person, your contractor.
My lord.
There is a separate contract between yourself.
Yes, my lord. And also, because in that contract, my lord, in that contract, all the NITs, the conditions of the NIT and other things has to be followed by me, my lord. I'll show all those.
So that is there, but it is vis-a-vis your.
My lord, now I'm coming. Now I step into the shoes of the corporate debtor.
No.
Yes, my lord. Yes, my lord. Why? Because, my lord, while I was working, my.
You encourage that. You are leader of the bar. You should encourage a disturbance cycle.
No, I enjoy, my lord.
It is like
starting for last 2 years, my lord, I am enjoying all this disturbance. I'm enjoying it.
Yeah.
So I know, my lord, how they disturb, I know it. From childhood is disturbing me, that is okay. My lord.
Yes.
My lord, what has happened?
What you say is standing in the shoes.
Yes, standing in the shoes and by silence, you have accepted me as a subcontractor. Because, my lord, while the 2018, from 2018, I have started the work till 2020, August, I have done the work. And you never objected those things. Never objected. Rather, you accepted a letter from the main contractor. And in silence, my lord, you have accepted that contract.
So, maunam sammati lakshanam.
Yes. My lord,
Avijnana shakunta.
My lord, now question is this. Now the contract is alive. Because if annexure 5, that the bank guarantee is alive, if that bank guarantee, if that contract and there is no closure of the contract, then my claim against MCL is also alive, my lord. Now, why I am saying so, my lord? My lord, may kindly see this letter first. This letter is very essential. 169, Annexure 6. This is in our writ petition, in my writ petition, my lord. And in this writ petition, MCL has not filed a counter judgment.
169.
Yes.
Were they?
This is written by erstwhile corporate debtor.
In Savai.
Where is the
WPC 25090.
Yes.
And it's a 6.
This was the letter which you had sent.
No, not I have sent.
Your contractor had sent.
Contractor has sent to engineer in charge, general manager, Hingula area. So subject is permission for engagement of the petitioner for the execution hard work in hiring of equipments contract. We have been.
This is dated.
This is dated, my lord, 1/2/2020. This is their receipt, my lord. This is the receipt done by MCL.
Paper book.
My lord, may see.
Do you have paper book?
Hard copy is there. Hard copy. Hard copy. Yeah, that is what.
You there.
It is sent on 30th January 2020, my lord, it was sent.
What it says, we have been awarded the work of so and so, so and so.
We have been awarded the work of extraction of coal and coal measures data by deploying surface miner on higher basis. Mechanical transfer of same by the payloaders is a tripping.
So he wanted permission to engage you.
No, my lord. Due to some financial crisis in our organization, we want to engage Siam and Transport Limited for execution of part work in the above hiring equipment contract. All terms and conditions of the agreement will be complied by the subcontractor Siam Doors and Transport Private Limited. 90% of running on account bill against the executed work.
My lord, done by you.
By
Siam.
Transport Limited
should be
deposited in the bank account of Siam Doors and Transport Private Limited. Details of which is remaining in our account, which is already furnished with you. So executed by me. By that time, the work was executed, my lord.
So how you can proceed against him?
Yes, my lord. Why? Why, my lord? Why? Now, my lord, first, my lord, he says that because of the clean slate theory, your claim has been omitted. Because under the resolution plan, your claim is omitted.
Yeah.
My submission is this: because of this letter, where MCL was communicated of this letter and they have received this letter in silence, under silence, an agreement has been created with MCL. That part, Article 38, which says that prior permission for subcontractor has to be taken, my lord, that I will read it out. That clause has come into being because of their silence. If they would have told,
Let us read that.
my lord.
This matter was heard by any other judges earlier, any other bench.
My lord, I will tell, my lord. First,
Just we want to know because some reports and other things.
this was, my lord, heard by Justice, I think. Justice
Some other bench.
Chairman.
Take us to that clause
My lord, page 52.
5.2.
Yes. Clause 7 of the NI.
Of the
NI. Notice in back intent.
clause 33.
8.
38.
38.
No subletting.
Yes. No subletting of work as a whole by a contractor is permissible. As a whole is permissible. Prior permission is required to be taken from a principal employer for engagement of subcontractor in hiring of equipment, transport, and contract for part work is rated work. My lord, no subletting of work as a whole by a contractor is permissible. That is absolutely denied. Prior permission is required to be taken for the principal employer for engagement of subcontractor in hiring of equipment, contract for part work, and is rated work.
Yes, I heard we have read that now. That it was says his obligation is not discharged merely by hiring some other contractor. The second part says.
Yes, my lord.
Now,
my lord.
Kindly see when you have given the letter.
My lord.
It is a question of prior permission.
My lord.
Not post work permission.
My lord, it is what they have done. I was working, my lord. I was not under the duty to take the prior permission. It was the duty of the corporate director to take the permission.
Correct. If that duty is discharged,
yes, my lord.
Then you will have a right.
Sorry, ma'am.
If that duty,
yes,
first part is right, what you say.
My
duty to take permission is not with the subcontractor,
my
but the contractor.
Yes, madam. The duty is casted on the contractor to take the permission from the principal employer. Now, my lord, kindly see the factual position. From 2018 till 2020, August, my lord, I was working. Till that period, during that period, my lord, I was executing the work, part work on behalf of the contractor. Their MCL knew about it. Because
prior permission it says.
Yes, prior permission.
Whatever work you have done, 80% work you say. As on the date the letter was written.
Yes, ma'am.
That 80% is not without prior permission.
Yeah, my lord, that work is without my lord is saying, putting a question that it was without permission.
Yes, without prior permission.
My lord, prior permission. The context of prior permission is here, is used or has been taken by the contractor at the currency of my contract after some time, after in 2000, when I started the work in 2018, they tried to take the permission in 2020, my lord. Now the concept is this prior permission, my lord. I am doing a job and this prior permission has to be taken by the contractor, not by me.
He has not taken.
He has not taken. But my lord, I had executed the work. There is no dispute to that. There is no
Question
dispute.
is not dispute.
No, no.
Question is obligation.
Yes, my lord. Where? If I have done the work, and MCL at no point of time
Raised any objection?
raised any objection
On the
that
other
why
hand, it
this
is your
work,
services.
why this subcontractor is giving these services, they have never raised any objection.
Yeah.
And they received it. After that, my lord, they said, I am not a subcontractor. They have not given me the prior permission. Now, this prior permission cannot happen. This concept, my lord, their action cannot happen of the post-occurrence point. If,
Any other point you have?
my lord, this is the very vital point. My lord, now,
What reason?
my lord, I have.
Any other point?
Yes, my lord.
Yes, please. Tell me.
Because, my lord, in this case, they have not filed a counter.
It's all right. You take advantage of that. Make obligation stronger.
My lord, see. Now, my question is this, my submission is this, my lord. When the contract is alive,
Counsel for the petitioner vehemently argues that the MCL was in the full know of the things which he was accomplishing under the contract in question, under the principal contractor, and therefore the kind of doctrine of quasi-contract would come in, imposing obligation on the MCL to pay for the work accomplished. First. Secondly, a letter was addressed by the principal contractor on 1 February 2020.
30th January
30 January 2020, specifically stating that 80% of the work has been 90% of the work has been accomplished by the petitioner, and therefore what is payable should be credited to his bank account. First, no decision was taken on that. Till what date it was not taken?
My lord, it was not.
You have never taken that.
Never.
At no point of time any decision is taken by the MCL, and therefore the first contention becomes more adumbrated. First one, having taken the services from the petitioner, the MCL being an Article 12 entity cannot act as a private entity and repudiate its obligations. What other point you want to say? We have added 2 more points to your submission. Yes.
My lord, regarding the resolution plan,
yes.
Can I highlight certain issues, my lord, with regard to that admitted operational creditors? I was put into the category of operational creditor, my lord.
And your claim is against MCL.
No, MCL, because in the resolution plan, my lord, they had admitted my claim. That's how, my lord, they say that.
They have admitted your claim.
Yes.
No, I have not admitted.
No.
The resolution plan is talking.
My lord, and the resolution plan, my claim against the corporate debtor of 6.53 crores, it reduced to 6.5. That was admitted by the
Resolution professional.
Yes, resolution professional, my lord.
Where is that?
My lord. Right. That is, my lord, page 206.
Mr. Patnaik, the petitioner submits that the resolution plan admits the liability of MCL towards the subcontractor.
Not MCL.
Not MCL.
Liability of the principal contractor to pay towards your client.
Yes, my lord.
In favor of petitioner. And therefore, the MCL is liable to pay for the work done. Now, where is that?
My lord, kindly see page 206. It is in the order, my lord, 206. It is, my lord, at 1, 2.
In resolution plan.
Yes, my lord. No, this is in the NCLT order, judgment. Where they have accepted the resolution plan, ma'am. An acceptance of the resolution, that order.
Which is that document?
My lord, it's 206.
M1.
That is, sorry, my lord.
M1 206.
No, amount is to pay.
No, M1, annexure M1.
No.
Then?
It is in my request.
Oh, it is in your request 206. How much?
206 page 206.
Yes.
Yes. 206, my lord, may I see 1, 2, 3. That is Siam and Transport Private Limited. That is 24/3/2021 when it was admitted. The admitted dues comes to 602 crores. 6 crores 2 lakhs. Now they say that because of the
Item number?
1, 2, 3. My dues were admitted, man.
This is a Sai-Om Tours and Transport.
Yes, the current petition, the present petition. So my dues were admitted, man. Now, because now in the resolution plan, man, I was accepted as a operational creditor, man. Admitted operational creditor.
Which is these columns are explained in which page?
Yes, sir.
These columns are explained. Headings of the column.
My lord, at page 198. Operational creditor, list of operational creditor, other than workmen and employees and government dues.
Details of claim admitted.
Yes, claim admitted. Here, my lord, at page 206, my lord saw that my claim was 6 crores and 2 lakhs, which was admitted, man. Now, coming to the...
What do you say about this?
My lord, that is between the corporate debtor and him. My lord, that claim he raised against the corporate debtor. My lord, may I see? There is a contract. There might have been a contract between the corporate and him. I don't know, because I am not privy to the contract. My lord, there might have been. Please let me speak. My lord, he has raised a claim against the corporate debtor. That claim has been admitted. That claim has been admitted by the RP, but no payment has been provided for in the plan, resolution plan for the operational creditors. So his claim is extinguished by operation of law.
I'm coming to that, my lord. How the treatment of operational creditors has been done in the resolution plan, and let me come to that. I'll read it.
This resolution plan binds whom all? Who all will be bound by the resolution plan?
The corporate debtor and his operational creditors and financial creditors. So it binds him and him, my lord. So MCL doesn't have a role. My submission, my lord. Legally, I don't have a role there because that claim was never put forth before me. It was put forth before the resolution professional of the corporate debtor. That was approved, but the resolution plan did not provide for a payment to operational creditors.
No,
so, my lord, that's a matter between the corporate. It is there on record.
It It is, my lord, let me first show page that, my lord, may see resolution plan 3.3. I am a operational creditor, my lord. In the list of operational creditor, I am coming. My lord, I'll place it, ma'am.
List.
Yes, ma'am. Resolution plan, my lord. 3.3. I'm trying best, my lord, to make out of this.
3.3.
Yes, sir. 3.3.
3.3 in
the resolution plan, my lord. They have given this. It is, my lord, page 50.
M1, page 50.
In this matter, notice was ordered to you.
My lord.
Notice was ordered.
My lord, yes, my lord.
And you have not filed any objection.
No, but it is because, my lord, this matter was tagged with this matter. Somehow, my lord, that on the first date when your lordship desired this matter to come up with this,
I had tagged, untagged is irrelevant.
No, I had not filed the count.
You could have filed the counter.
My lord, I did not. I have not filed the counter as yet. My lord, that is.
Yes, Mr. Pratap.
Yes, the treatment
of operational creditors. Who are operational creditors?
Yes, sir. I am the operational creditor. Lot of list, my lord, was given. There were around more than 200 list was given. And as for the, my lord, now I am.
What is meant by operational creditor?
Operational creditor, my lord.
My lord,
It is defined there.
It is there. It defined.
Whether he fits into that definition.
It is admitted, man. That list is of the admitted corporational creditor. It was admitted.
Because it is enlisted. Because it is enlisted.
Yes, ma'am. Enlisted. It was admitted. And now, my lord, it highlights that one. See.
Operational creditor, my lord, means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. Then operational debt is defined just below. Means a claim in respect of the provisions of the goods or services, including employment or.
Then it fits into the definition.
Yes, my lord. But an operational creditor of the corporate debtor.
My lord, corporate debt.
Here it all talks about.
Let me explain.
My lord has asked me a question. My lord, this operational creditor of the corporate debtor.
Yeah.
So, my lord,
so who is the debtor?
Even in this case.
Who is the debtor? Debtor is now, my lord, has been replaced by another company of a growing concern, my lord. It is not a debt concern. It's a growing concern. And funds are infused. My lord, at the BS I am submitting for a growing concern, some funds are infused. Not that in the later date, the funds will not be infused more. Because it's a growing concern, so this limited fund is infused. Later on, some more funds will be infused. It is not a debt concern. Liquidation has not happened, my lord. If liquidation would have happened, then otherwise other things would have followed.
No,
it would have been auctioned, it would have been done. Now it's a growing concern. So like a more thing is to be invested, my lord. My lord, I'll read it out, my lord. Come on.
I may be excused by that item 3. My lord has directed me to supply him the auction purchaser name and address.
Yes.
You have supplied him.
You have supplied.
Supplied him.
The petitioner is directed. We are directing you so that you can implead them. There is no separate application needed. Petitioner borrower is directed to implead the auction buyer whose particulars have been furnished by the panel counsel appearing for the bank. First, you amend the cost title. Cost title to be amended immediately. Issue emergent notice to the additionally added OP.
The auction purchase.
That is auction purchase.
Auction bidder man. But he has to pay another 75%.
Anyway, he has a purchaser.
May I be excused? In the present case which is going on, my lords, in that case, I am appearing for the bank. I have no role to play. I am only a pro forma opposite party. I have personal work.
One submission, your lordship will continue this matter.
Yeah, because we want to finish up this matter. We will not adjourn it again.
Lord, the only difficulty is I have some commitments post-lunch. That is my difficulty. Let him complete. Let him complete because I would like to respond to submissions of Shamanti.
You complete and come back. Will be on
I don't know.
Tomorrow morning.
No, let him complete. I will not stand in the way of completion of their argument.
No, it has
Only
to be
with
when you
regard-
are present. We have to make
No,
that submission.
my friend will be here. That's not an issue.
Can we take it up on tomorrow morning, 10:30, my lord, because, or tomorrow 2 o'clock, if possible. Because I have something.
How many matters we have posted tomorrow?
16.
16 already we have posted. That's the reason. Because now we have understood the frame of the case now. Though you become an entity under the resolution, that is qua the principal contractor of MCL is his version. That you have to address. We'll have it tomorrow. You just examine and bring some rulings.
At least tomorrow 2 o'clock, my lord. 2 o'clock. Thank you. Because there are some because of Bhubaneswar Bar is something organizing, so I have to go there, my lord. So that is the whole problem, my lord.
That two fields.
I can manage to feel.
We can't give the
Begging pardon, your lordship. It was not intentional.
I'm saying not that. Without you sought for interim prayer order without mentioning that you have not filed a.
Actually, it was my unawareness because I have not gone through all these things. For the first time, my lord, I am begging pardon. Next time, I will not do it again.
You are for the bank. Now, what should be done?
Actually, due to non-payment of the outstanding dues, attend to notice, demand notice was issued in 23/4/2025.
23/4/25.
60 days was given opportunity to repay the amount.
Anyway, if he now pays, after all, bank wants the money. Bank wants the money back. That's all. So, what is the order we have made now?
I prayed for 3 months extension for period of so that he can pay the entire amount. Your lordship has given 2 installment after 3 month extension.
So
One line.
if he pays money within 2 months,
My lord.
till then you halt the proceeding.
My lord.
Right? Within 2 months, if he does not pay,
My lord.
you take coercive action.
Your lordship has given 3 months.
No, for this entire payment, we are giving you 2 months now. Within 2 months, you should pay back the money.
Your lordship has given 50% in 2 installment. Means in 2 installment, we will repay the entire dues.
In 2 installments.
Yes,
How much it is?
24 lakh,
24 lakh something.
22.
So
29 lakhs, 92,940.
around 30 lakhs it will be.
No, your demand notice was 24 lakh, 22,539, and till then.
Yes, your lordship.
Yeah, correct.
Adding the interest and all.
Right. 29 lakh.
Now it has not gone beyond the 13.2. It is at the stage of section 13.2.
No, what happened, my lord? Thereafter, possession notice was issued, and subsequently, bank has given ample opportunity by issuing another 30 days notice that before issuance of e-auction, if you will pay the entire amount, we will not take any step. That has been already expired.
Your lordship, sale notice has been issued.
No payment.
No
response.
sale notice is issued.
Sale notice.
Not yet.
That's why I.
30 days given. time was-
Sale notice already issued in Annexure 3, your lordship.
No, that now the period has expired.
That's why I'm praying for the extension of time, your lordship, because his father is ill, 91 years old.
Everybody will be ill only.
And
After
disturbances in Middle East, your lordship, loss of
and become well then.
loss of business, your lordship.
That sale notice, that is not sale notice, giving a right to redeem the sale property, secured property, 30 days time was given.
No, your lordship, sale notice has been affixed on the wall of the house. It's
Now, council is saying, nah.
It's a question of reputation of that gentleman, your lordship.
That the reputation is always like that only.
Already-
Reputation, whatever money is taken should be paid back.
Your lordship
have
has
paid
already paid more than 75% of the loan amount. Your
You
lordship.
have paid 75% of
Yes,
money is
yes,
paid
your
back.
lordship. That's the point.
Because
And he's very eager to pay the entire amount, your lordship.
You pay it now.
But no money. That's why I need extra time, your lordship.
Without money.
3 months you have given, your lordship.
SIP has reached or not? That SIP has reached.
No, sir. Yes, your
When
lordship.
that ship will be coming, which shore it has left? She has left.
For that, your lordship has given 3 months of time duration. Otherwise, the coercive action will be taken against us, your lordship.
2 months we will give. Within 2 months, we will clear it.
Humble request, sir. 3 months.
No. The essential grievance of the petitioner borrower is against coercive action of recovery taken under the provisions of section 13 of the Surface Act 2002. First, the Learned Counsel for the petitioner submits that if a period of 2 months is granted, entire amount would be
I have 2 installments, your lordship.
entire amount would be paid back, and that he should be given easy installments for making the payment. First, learned panel counsel appearing for the bank opposes the proposal, contending that despite grant of several opportunities, the debtor has not made the payment, and therefore he is not a scrupulous debtor who is entitled to relief at the hands of the Constitutional Court. First now, next paragraph. Having heard learned counsel for the parties and having perused the appeal petition papers, we are of the considered view that some reprieve needs to be granted to the petitioner in as much as substantial amount of loan he has already cleared, and he is assuring to clear the remainder within a reasonable period, that is 2 months. First up, the bank is after all to get the money back lent, and for that purpose it has got the property by way of security for the repayment of the loan. First up, nothing will be, no prejudice should be caused to the bank if another period of 2 months is accorded to the petitioner. First up, in the above circumstances, this petition is disposed of, granting a period of 2 months to make the payment, to make entire repayment.
My lord,
As
Installments.
under. The first installment shall be installment of rupees 10 lakh would be paid within 21 days, within 3 weeks. Within 3 weeks. Semicolon. The second installment of like sum shall be paid within 3 weeks next following. 3. The remainder shall be paid within 2 weeks following the said period. Period. Prescribed immediately above. Immediately. If the amount is not paid, if the breach is committed, comma, it is open to the bank to proceed against the property in question or person of the debtor, as the case may be, in accordance with law. In that connection, full liberty is reserved. Okay.
Grateful.
Question is done. Item 10.
May I please borrow?
Yes, sir.
Reason is the petitioner in this petition, who was earlier, who came before this honorable court, being the opposite party and being noticed, I take your lordship straight to page 38 of my writ petition, in
the prayer.
Earlier writ petition, the disengagement of the workman who was temporarily appointed was assailed before the labor tribunal. Since labor court held the termination as just and proper, he approached this honorable court in the previous writ application. And 38 is the conclusion part of the direction given by this honorable court in the previous writ petition. My lord held that accordingly your lordship decided that we set aside and quash the impugned order. The matter is restored to the labor court for consideration on the question of
impugned order or award. Is it order or award?
No, order of this
petition. Order elsewhere.
Order of this honorable court in previous writ petition, my lord, I am referring to. Page 30.
Annexure 3.
That is, my lord, Annexure 3, page 38, last portion of the order.
Reinstatement and compensation for wrongful
question of reinstatement
retrenchment
or compensation for wrongful retrenchment. This is the final, no question of looking back, my lord. Accordingly, my lord, the labor court what happened? Instead of granting either reinstatement or compensation, in my humble view, my lord, granted both.
You can't read the judgment like a statute of Westminster.
No, not like that, not like that. Here my lord, he was directed to be reinstated, also with full back wages. That disturbed the management, my lord, for which the writ petition, that 100% back wages.
When he was retrenched?
My lord, 6/11/2010. And let me.
What is the ground of retrenchment?
It was temporary appointment on a flux of time, my lord. When the period of temporary appointment came to an end, a notice was given, 1 month salary was given, all formalities were followed. Be that as it may, my lord. However, honorable court held that termination was back. No question of looking back, my lord. Now the purpose is to see honorable court's direction is followed. Now, because learned labor court, my lord, granted both, all reinstatement with 100% back wages, my lord. But when the matter stood thus, a miscase was filed by learned counsel for the opposite party, number 2, the workmen, for seeking release of arrear wages under section 17B of the Act. My lord may see that
last on pay.
Yes. I was directed, my lord, to file my objection affidavit, and objection affidavit I have filed, my lord, in obedience to your lordship's direction given on 3rd of December 2020.
Now we will dispose of the main matter itself.
My lord will dispose of everything.
Main matter itself.
Everything, my lord. Yes. Now, what I have in 17B, I wrote to him, you please come and join. Your computation shall be decided from the date of joining. To which he responded, my lord, like this. Page 7, my lord, may kindly see, of IA number of my objection affidavit. Objection affidavit, my lord, given, filed on 15/1/26.
Yes, what does he say?
He responds to the MD, my lord. Second part, since I am out of employment for last 15 years, my lord, on the above background, bottom paragraph, my lord, on the above background, I received your letter dated 20/12/25 on so and so. I am now thinking over your proposal of joining on contractual post at the same remuneration last round as on 6/11/20, where my co-employees, wrong, but in similar category are drawing 32,000 some odd per month in January, and now being regularized in service. But I am in need of urgent surgery, for which not able to join and waiting the outcome. Person filing an application under section 17B demanding release of arrear salary responds to management's letter like this. And on top of it, my lord, my learned friend on last occasion, with his kind permission, my lord, I am making this submission. He proposed that now he has changed his mind, not to go for reinstatement, but to take one-time compensation. If I may be
Just tell which is-
affirmed by my learned.
Do you agree with that proposal?
Yes, ma'am.
It's a golden handshake.
Yes, ma'am.
It's what
Golden
is-
handshake, he was never in service. No golden handshake, he will take one-time compensation.
No, because there is an order.
Yes.
My lord,
There is an award now. Reinstatement with full back.
full back wages.
So it will place him in the employment with retrospective effect.
I was willing to give him employment with retrospective effect. Only 100% back wages, full back wages was subject matter of challenge, man.
No, anyway,
Now,
you want,
when it comes to the money, one-time compensation, my humble statement would be, my lord, I have discussed with the management, 12 lakh consolidated amount towards one-time compensation, which was also raised before the learned tribunal bill.
That was also their proposal before the labor court, my lord.
It is official.
My lord,
now if we admit this matter and keep it in the regular row, another 5-6 years it will not come. So instead,
it is up to my lord to decide whatever compensation we will accept.
no, I will not decide. Since you are deciding,
Statutory dues, gratuity and provident fund is also
12
my
lakhs,
due.
12 lakhs he is saying, you quote your number.
We have that in the labor court, the workman proposed for 32 lakhs.
32 lakhs.
Man.
He wants to go for buying a lorry or what?
No, that is a area wages, man.
We are telling that this matter requires deeper consideration. See, after Lilly, the stand of the Supreme Court has seen. Earlier, the burden was on him to say he was gainfully employed.
My lord,
Now
the
you know
workman has
that-
left everything to your lordship. You
I don't
can't-
leave anything. I don't want any money at all. I'm very happy with the salary the government is paying.
Whatever your lordship decide, we will
No,
accept.
not like that. Now he has come out with some number. He says 12. You say 32. Between 12 and 32, there is a big sea.
Man.
Or at least there is this Mahanadi. So you have to squeeze. Both of you have to make extra distance, extra mile you have to walk. And if you come to a settlement, we will record the settlement. Otherwise, you argue your case, he argues his case, and we will do whatever we want to, according to law.
My lord, we leave everything to your lordship.
Don't leave anything to us.
Let me explain,
Yeah.
my lord. Since my learned friend indicated that statutory benefits, let me make very clear, my lord, there is no 0 paisa claim towards any alleged statutory deposit. Reason being his employment was temporary in nature and he served only for a year.
Shall we
20 years
tell
ago.
one figure to you?
My lord.
Think about that.
Right.
And he may not agree also, but we are thinking that way. All right. Don't think that we are giving a pink slip to you. We are not giving pink slip. We are only writing on that. Only for your eyes.
I need to kindly fix it to tomorrow, whatever time, my lord. I need to appraise my management.
Tomorrow. Or next week will happen.
Tomorrow it will take. If not incumbent, it will.
If he is not agreeable, then we'll whatever the.
My lord will, on merit, my lord.
Give that slip back. This is the number to be given to him. We are making it clear that you should not say that judge has asked so much for deciding the matter.
No, not at that.
Tomorrow.
Under orders,
Well, put it in order, please.
Orders.
Both the sides seek short accommodation to work out an amicable settlement. First off, call this matter tomorrow. Yeah. You can ask, and your client can ask to sit under the shadow of this order so that you can take out that matter further.
Item 11.
My lord.
Yes, sister.
My lord, the similar order which has been passed by the Lord's Tribunal, my lord, has been implemented by them, my lord.
Is it true?
Yes, my lord, but there is a little difference. I'll
Between these two cases.
You know, the copy has been given to me. I have taken instruction.
What is the differential aspect?
Lord,
My lord, I'm
No, we have agreed with you now. Difference he says he has to show.
Yes.
Still you want to argue?
no, my lord.
We can argue.
I agree on the point. This order has been decided. What my learned friend is placing before my lord. The only thing is the person was regularizing out of the procedural order in 2015.
Regularization, other order.
Lordship, may I just pass on the data
Yes.
for my convenience to place the matter.
Give two copies so that.
Lordship, I have already given.
You have given? Already given.
On 9th, only few dates I'll mention, Your Lordship.
In the date chart,
Lord.
item number 2.
Lordship, that part has already been clarified by the office memorandum that because these are artists, they cannot be dealt with laborers or working for 120 days at least. So their working hour was calculated and accordingly said, because they're artists, if they have worked for 30 hours in a month, then also they will be subsequently considered as 120 days in a month, as per the OM. Subsequently, there was a notification, Your Lordship, office memorandum. Your Lordship, may kindly pause for a moment that I have annexed to the writ petition.
They are makeup assistant.
Makeup artists.
Makeup assistants are workmen also. There are judgments.
But that has been already considered by the department, and accordingly, department considered that if they have worked for hour basis, so do not consider them for 120 days, and accordingly you may regularize. But the only thing that was put in the office memorandum that in the particular center they are working, in that center only if the vacancies arises or vacancy comes, then you can adjust them. So this man stands at a second footing. The first footing, the person he has regularized in 2005.
How many years of service he has put in? He is
from 84, my lord. He has first engaged in 84.
You are working since 1984.
84, my lord. 1984.
Is it true?
Yes, ma'am.
Up to 92. Because in
84 to
84 to 92. Yes, regularly working. Because they're casual employees. They're called when they're needed for a particular job or anything of their assistance. So regularly he was rendering his service from 84 to 92. In 92, one notification came that if they have worked for 120 days, then they can be regularized. My lord, for that you will also may kindly see the point number 2 in my date chart.
That came in the year?
In 9/6/1992.
9/6/92. Under this, she is entitled to regularization.
And he was put in queue.
Because there were others.
Yes, there are others who are to be regularized before he is regularized. Or his case was to come.
In the queue, what is the number?
Second. Second. In 2015, Your Lordship, there is the change.
Yes.
1
minute, my lord. In 1992, they approached the Honorable Tribunal, Law and Tribunal, my lord. And Law and Tribunal directed to make a scheme for regularization of the casual artist, my lord. In 1994, the scheme was made, my lord.
Yes.
In
1994.
In 1994,
Yes, ma'am.
some scheme was made, my lord, of
Yes,
casual artist.
Page 26 of the writ petition.
They assailed the order of the tribunal before the Honorable Apex Court, my lord, in 1996. And before the Apex Court, my lord, they have submitted an affidavit that we have been regularized.
Which is not true.
But
It was a concession given by the advocate without instruction. They have agreed and we also agree to the position.
in 96, they have submitted that we have been regularized. On that, taking into the consideration of that, the writ appeal against us was dismissed, and SLP against us was dismissed. Again, they tried to restore that, file a restoration to that SLP, but the Apex Court did not restore the SLP, my lord.
That was the request was rejected.
Yes, my lord. And my regulation pending since then, my lord. And in 2020, my lord, a scheme was formed by the central government, my lord, where they have stated that the person should happen. My lord, may kindly see page 61 of my counter affidavit, my lord. They have regularized me in a post which was vacant since 2002, my lord, in 2015, my lord.
Mr. Pari,
Yes.
you have misled the Honorable Supreme Court by saying all these people have been regularized in service. And therefore, the Apex Court dismissed the petition saying that it has become infructuous. Thereafter, you made an application for recalling of that order. That was dismissed. Is it not fraud on the highest court of the country by the central government?
Well,
That is a fact, Your Lordship. And Your Lordship, for that reason, the counter, they have also admitted the situation and we have also recognized. Yes.
just paragraph 8, you have described all this.
No, described is a thief saying, yes, true, I have stolen the goods. Then can he be left out that way?
That's true. It cannot be.
Then grant relief. Otherwise, you will impose about 10 lakh rupees cost. You take it to the Apex Court. Playing fraud on the highest court of the country. And fraud is not by laborer, worker, farmer, or pagan. It is by the central government. Fit case for imposition of 10 lakh rupees cost, plus order for regularization.
May I pray one
case only.
May I pray one? Because we are a petitioner and this counter paragraph 8, they have described this. It's equal to be filed to rejoinder or the contributed in this.
Why? What rejoinder?
Because what allegations they have made against this issue.
No, you are admitting that.
We are admitting.
Your date chart.
To the extent.
Your date chart admits that.
Yes.
Yes. They were not disputing, my lord.
Yeah.
But what I am saying, my lord, what circumstances these things happened, it is required to be enlightened to the court, man. There must be some submission or some document basing on which the council who is appearing with the Supreme Court and submitted the same, it must be brought to the notice of the Honorable.
And it was brought to the notice of the court by your application.
Yes.
Seeking recall of the order. That is rejected.
Not before this is before that.
Even before the Supreme Court, it
Yes.
is rejected.
So, that's what is the circumstance I want to only clarify this position.
No.
Because man, it is very essential. Because otherwise, what happened, Lordship, what observation is correct that we should not be any unfair with the Apex Court and
any court.
Yes, any court.
Let alone
Yes,
Apex
yes.
Court.
So in this regard, so Lordship, I give you one chance. Then within 5 days or 7 days, we can enlighten the court. Otherwise, I can Lordship, with my no answer, I can concede the court that it is on mistake.
No, otherwise, whatever benefit, what is your relief you have sought for? What is as a concession if you do that? We may
we're agreeing to that.
Impose the cost.
Yes. The only concession they are seeking that consequential benefit from 2002, though he was never appointed in 2002, but he was appointed in 2015 only. my lord.
The post was vacancy was available in 2002.
But the vacancy not in the place he was working. In a different place in Calcutta itself.
Very well.
He was working in Bhubaneswar.
Posted here.
You could have posted there only.
Lordship, to the extent that has been passed, but the judgment that is being of the Honorable Tribunal that is relying by my friend, that says.
I am not relying on that judgment. I am saying that similar person in
My friend has already placed the judgment. If not relying, then.
Those who are on similar footing,
yes,
their order has been complied with. And they have assessed this order.
Yes. Because it was in 2024, subsequent order in 2025. So we are agreeing to comply with the order as per 2025.
Just one more opportunity now to choose any one of these two. Granting regularization with retrospective effect from the date when the vacancy arose in 2002 and granting all benefits thereof without interest. Whatever had he been regularized against the available vacancy in 2002, what all the employee would have achieved, an artist, he would have got. That should be given to him. This is first option. The second option is, we will hear your argument and we are proposing to impose cost of rupees, minimum 10 lakh rupees. Because you are a big entity. You are not some Sahu, something like that. You are a central government. The correct message should go to the officers and coupled with option to recover that money from the erring officials.
What I bring, my lord, with all this in Durdarshan, especially in Durdarshan, those are working in different capacity, or a tabligh, or any capacity they are working. Hour-wise they are working. It is not a full working days. But thing is now this, if they regularize as a regular employee 2002, I don't have an objection, because if the Supreme Court has observed in such a way and my lord is observing as a rightly is observing, I am not standing the way. What I am praying, my lord, Lordship, this first option Lordship is given for regulation 2002 and the benefits is concerned. I am considering to the extent, my lord, that Lordship give me at least 3 days time. In the meantime, I will
call on Monday. It's the request of DSG Party. First thing, how's the matter? Substantial. But call this matter on Monday for further submission of Mr. Body. But we are very clear in that.
No, I appreciate
our costs are generally on a higher side. We don't go by Panipuri cost at all. 5,000, 10,000, we will never do that. That will not defeat the
judiciary, we have highest respect to that. I can't stand on the project.
Yes.
Item 12.
You have to come out with a proposal. What you are going to
say? Definitely.
Yes.
But item 12, I'm praying for time, 1 week time.
Next to 2 weeks. Yes, it's a request now.
Item 13.
Different cases are there, filing the list.
Yes. Any other connected matters are there?
No. Three connected matters there.
Compassionate appointment 2018 window is voting.
Next.
Item 13.
May I please your lordship?
Yes.
My lord, this is a matter regarding payment of revised pension to the petitioner, to the appellant. The single judge, honorable single judge, has negated the case on the ground of misconception of the factual position of the case. That is my case. The sole point is that whether I have retired from the post of multi-purpose health supervisor or in the post of sanitary inspector.
In which post you retired from?
Actually, I have retired from the post of multi-purpose health supervisor. So for that purpose, I have prepared a written notes. Actually, the case has got a little brief.
You retired on 3694.
Yes.
From which post?
In the post of multipurpose strength supervisor.
Where is the material?
I have written everything. Let me start with.
Only that much. What is that? Start with.
Yes.
Only one question.
57. Page number 57 and 58. In the caption read petition. In the caption read petition.
In the read petition.
In the caption read petition, that is the read petition number 34311 of 2022.
Page 57.
Page 58, 57 and 58. Let me see. Yes. In the page number 57 and page number 58. First page number 58. 58. In the 58, this is my retirement order. Page number 58. That is my retirement order. It has been issued where the working last. That is the PSC. What bonders of PSC?
58 of WPC.
58 is the caption rate petition. That is the rate petition number 34311. Let me read it.
My lords, the writ petition is not annexed here, and I don't have the copy also, my lords.
Petition, writ petition, what this writ petition, the WA has been filed.
But everything you have to produce is an appeal.
I have given it. Previously, I have given all the copy.
Writ petition.
Give one more copy so that we can see. He will read and come back. Otherwise, he will take up a contention. The court did not give us opportunity, and he will be justified in saying that.
They have quoted it in the challenge writ order. They have quoted it. Everything is there.
Appellant to serve a copy of the appeal paper book.
My lords, writ petition. Appeal memo is there.
Appeal memo have
Connected writ.
the paper book of the WP along with all the documents. So that learned AGA would be in a position to take up stand.
So there are two writ petitions in this case. One is the WPC number 34344 of 22.
Both you give. Both WPs. Right? Both WPs.
So let it be posted on 24.
24? Huh? How many matters?
Sir, only do.
Three. Put one more. 24. See, so it's appears for which accountant respondents. Okay. Next.
Item 14.
Yes, Mr.
But challenging the past by of single judge. The short issue is Odisha Industrial Housing Accommodation Act.
Such an act is there.
The Odisha Industrial Housing Act 1966. In terms of that act,
transfer of ownership.
Yes, quarters are allotted in favor of the industrial workers. Now, during the continuation of that occupation, they have promulgated a resolution and rules that those allotted quarters should be regularized in favor of the industrial workers who continue to be the industrial workers and are in possession of the share, who are bona fide industrial workers and are in possession of the share.
Industrial workers means who? Any definition is
under
there?
Under the Factories Act. Industrial workers under the Factories Act. But that rules, the Lordship would kindly turn to page 81. I'll just show that rules, the condition of those rules, then I'll take your Lordship to the judgment and it's page 81.
These rules are promulgated under Act only.
This is a resolution.
Means?
This is a resolution issued by Government of Odisha, Housing and Urban Development Department. They say the transfer of tenements constructed under integrated subsidized housing scheme for industrial workers and economically weaker section of the society.
No, what is the status of the resolution?
But status of the resolution is only in furtherance of the act only.
No, which section gives the power?
But that is there in the collective C.
Trace the power.
Yes, sir.
Government cannot deal with the property
Right.
as the private owner.
That's why I've been saying it consistently.
Yes, Apex Court has said, not me. I'm only reiterating what Apex Court has said.
Right. But in terms of this resolution,
what is the source of power for drawing the resolution?
Also the letter of the Government of India.
Government of India letter, pursuant to Government of India letter. What is the source of power of the Government of India?
I don't think anything is.
These are all private property, the properties of the state. We are in federal structure.
It is written further instruction are issued by the Government of India in their letter dated so and so. The posting of transfer of these tenement were under active consideration of the Government of Orissa for some time past. Thereafter, my lord, after careful consideration.
No statutory power.
We are in a federal structure. Center state.
Right.
How can center direct? States are not the vassal units of the center. How center can give such letter? How state government can pass such letter? Otherwise, no property will be safe at the hands of the government.
Questions not only can be answered by the Union of India.
Since you want relief, you have to answer.
But that in fact, I don't find it anywhere in the resolution.
Then we will dismiss the bill.
But consequently, effect of that is again, it is allotted to someone else.
Now that we will examine.
That is the point.
What is your locus standard?
But our locus
rights should arise under the statute.
Right.
Not by the resolution, memorandum. We will not.
But by virtue of this resolution, they are cancelling my allotment and giving it to someone else of the similarly placed person. That's the issue. Kindly see, allotment is on the basis of the act.
Allotment is under the act.
Yes.
Which section says?
Section 6. No? Section 6.
Read. Give that act.
Yes. Allotment is section 7. No, factory act. It would I give a copy. But people actually holds it that it cannot be given at all despite the resolution, then no one can get it.
No, that happens. We have to abide by law. Whether anybody gets or not, we can't say that because policy we have taken to do the justice according to law.
That's right. Kindly similar section 7.
Cancellation of allotment.
Allotment of houses and conditions thereof.
The allotment of houses shall be made in the prescribed manner by the housing commissioner on an application made in that day and shall be subject to such terms and conditions as may be prescribed. Allotment means what?
Allotment of this quarter.
It is by license, lease, mortgage, ownership. How it is defined?
It's monthly lease basis.
It is lease.
Yes.
Not ownership at all.
No, not at all ownership. It's only subsequent to that.
Allotment is defined there. Section 2A, B.
Right.
Allotment means allotment of a house in favor of an industrial work made in accordance with the provisions of this act and the rules.
Rules thereon.
House means so and so, rules to arrange.
If the committee is something like that, then housing commissioner is there. Then procedure and conditions of allotment, rule 12.
As per the act.
Rule 12.
Rule 12. Procedure and conditions of allotment. Whenever houses are vacant, likely to follow left out. We shall issue. This is for only a lease basis. Letting. The number of houses available for along with the terms and conditions of allotment. The same notice shall be published on the notice board of the housing commissioner. As many copy of then here so the housing commissioner will say so many the tenements are vacant and available for allotment. Then where it goes to?
Allotted.
Who will allot
It
them?
was allotted to, now I'll take your lordship to those facts. Kindly turn to the list of dates, I think. Not kindly turn. There is a list of date at the top of my appeal. 24/9/77. Lordship got that list of dates.
No. Do you have a hard copy of that? One
Your
copy?
lordships are not having hard copy. I'm sorry. Can I hand over him?
Yes, we'll get
I'm sorry, but it will be
No,
single
it's
one for
fine.
both your lordships.
Date chart is here, no issue. It's here now.
That is the date.
All right.
But 24/9/1977, the tenement J4 was provisionally allotted in the name of the appellant. That allotment is at page 68.
Yeah.
Then 21/12/1977, allotment was made final at page 69 of my brief. Then 28/12/1977, possession was handed over to the appellant. That is at page 70.
Subject to what conditions?
That your lordship.
Allotment was for what period?
That kindly see page 68, then 69. 69, page 69.
All right.
Let's get page 69.
Yes.
Yes, these are the conditions. Allottee shall pay rent and other dues for each month on or before 15th so and so to receive me. The allottee shall not assign his right of tenancy and shall not sublet otherwise or part with possession of the house or any part thereof. The house will be used and occupied for the purpose of residence only by the allottee and bona fide members of the not otherwise. Damage is called so and so. The allottee shall keep house in clean and sanitary condition. Allottee shall not allow water from any so and so. Then last your lordship may see D. As soon as the allottee ceases to be a worker as defined in the Factories Act, he then he sent intimation of the same in writing to the Housing Commissioner Odisha.
Then what happens?
Lord, kindly then turn to, but this Odisha Textile and Steel, the industry.
Now, what is the significance of last point which you have read now? He will intimate that I seize it to be.
Obviously, his right will seize.
So he will lose the allotment.
He will lose the allotment.
All right.
I think though consequence is not provided, but that should be.
That's the meaning.
That's
Otherwise,
the
you're right. You're more than right. All right. Whether your client is a even now he is a factory worker.
Beg pardon, madam.
Whether your client is
Yes.
factory worker.
Lord, he was an employee of initially Odisha Textile and Steel, which is an industry factory. Then that industry got bifurcated into two parts. Petitioner was observed in Koningo Textile Limited, so and so. That's the part of that OTS. Then the dispute arose. If your lordship will see.
No, does he continue to be a worker as in today?
Today, he was up to 2005. Now,
done nothing.
Now, your lordship may see. Lord, while the matter stood thus, the industry where the petitioner was working was laid off in terms of Chapter 5 of the Industrial Disputes Act. It was laid off. Now, at that point of time,
layoff also brings an end to the vinculum juris of employer-employee.
That's right. That's the position. But that layoff was challenged in the Industrial Tribunal and it was declared invalid. Now, it is at that point of time, but I'll show that order to your lordship. That is at page.
The question is, as of this day,
yes,
are you a worker?
As on the date of that resolution, he continues to be a worker, which has been wrongly held by the Honorable Single Judge that I am ceased to be an industrial worker.
Yes.
That's the point.
Yes, but the question is, we will not give effect to this resolution at all because matter is covered by the statutory policy.
Then right of everyone goes.
Everyone goes. It goes.
So that position, I must admit before my lords, if your lordship holds that the resolution has no legal stand.
No legal stand at all.
Then right of everyone goes.
There is no right at all. Where is the question of going?
Then I did not proceed further. If your lordship says that the resolution is bad itself.
It's bad itself. It cannot.
Then no one can get it.
Nobody will get it.
That will not let me take instruction on that. That government of India, the government of India's instruction on the basis of which the resolution has issued. But I'll have to find out the source of that notification. Lordship, give me a short date for that. I'll come back to your lordship with that instruction. If I find that
for whom?
The rival allottee.
Rival allottee.
Private.
Whether your client is still workman?
No.
He is not workman, but still he wants to retain the property. That he cannot.
If the resolution will go, my lord.
Everyone will go. Let us take instruction on that.
Otherwise, no public property will be preserved.
My lord, not only these two persons.
Hundreds of people. They have to. The property of the government is not for the politician to allot it as a freebie. They are the properties of the state.
We'll have to bow down before my lord. Subject to before that, we should
clarify.
Yes,
clarify.
Get clarification, my lord. Before your lordship kill us.
Matter was heard at length. Yeah. First off, learned senior advocate Mr. Rathod and learned senior advocate Madam.
I am not a senior advocate.
But anyway, counsel Madam seek a short accommodation to come out with some more instructions at the hands of their client. First off, which date you want?
2 weeks time.
Whichever date you want, we'll give you.
Your lordship may kindly keep it to 25th, my lord.
Call this matter on 25, 3, 2.
My lord, can it be sometime first week or second week of March?
Right. That is March only. That is March.
I'm looking.
Second week is 12/3. 11/3. 11/3.
Whenever your lordship. Continue to my lordship. Whenever.
11/3 of 2023. 11/3/26. Before this bench, post this matter, before this bench only for further hearing.
Right.
Everybody will go. All the
Everybody will go. These are all properties for the posterity. We can't just them to throw the properties at the hands of people in the market. These are all state properties.
So let me.
It's our duty. Supreme Court said it is the duty of the Constitutional Court to preserve the public property. Otherwise, anybody will give anybody's property. These are not the properties of the politician. Therefore, by resolution, it can't be distributed. We'll just ignore that resolution. Take this.
That is entry model at that point.
No entry.
No, that is there.
That's there, but we are discontinuing it. Unless you make out a prima facie
I'll be evicted.
You will be. Unless you make a prima facie case.
Till that date,
where is the
till your lordship considers it,
no, where is the case?
But someone else will come in. Your lordship may kindly consider. I am continuing. I am having my children there.
Someone ke mu to bhi achi na beti. I am also a party. How can I go? How can I go?
So
but both of us.
You all will go by the court.
But that's fine. But till that date, your lordship may kindly. It's already there. Having found a prima facie case, the interim order was passed by this honorable court. Kindly consider.
When it was granted.
Kindly see, my lord.
While issuing notice.
12th of September 25, it was granted.
But the charter should not agree with that. We don't agree with this.
The issue which your lordship now is not
your lordship will not
say
not finally
that was never been
till that date. Your lordship may not go.
Since 95 till date, my lord, that issue has never been
We will decide that. We will not leave it undecided.
Right, bro. I know your lordship.
Entry order to continue only till 2026.
For last 30 years, the issue remains as it is.
We will decide it.
Item 15 has been adjourned. Item 16.
Yeah. Who appears in that matter, in that property matter? Government, you are appearing. You have to come with preparation. Yes. May progress. Not to do anything.
May I please? This is you have challenged the order of the Honorable Single Judge Miller, deciding Miller 2 writ applications and dismissing both the writ applications. Deciding Miller both the writ applications are dismissed.
Both the petitions by the same party.
No, both the petitions rival claim. Miller. I was a petitioner in that case. Respondent number 4 was also opposite part number 4 there. Opposite part number 4 was also filed a case relating to appointment of Hon'Ble workers. Yes, my appointment, I secured 455 marks and she secured my opposite part number 4 272 marks.
Why Learned Judge was not impressed by this argument?
Because the earlier my lord, this honorable court directed the matter to be taken up by the first appellate authority and the second appellate authority. Under the statute, there are 2 appellate authorities. First appellate authority found my lord in my favor. The allegation made against me was found to be incorrect and held my appointment as valid and held that the appointment of opposite party number 4 is invalid. But notwithstanding that matter, the second appellate authority considered both the matters and said no, those two are not eligible.
Both are not eligible.
Yes.
On what ground?
That is on the ground my allegation was.
On what ground he stated this?
No,
afterwards you can argue.
He stated that the authority, the first appellate authority thought that I was my area was within that service area. That was found to be not correct.
The appellate authority said, second appellate authority said, both are not from that area at all.
Yes, ma'am. No, not both. The other man lacking educational qualification.
Therefore, he was not given.
Yes.
She was not given.
Yes, madam. But the first
one sees on the ground that you do not hail from that particular area.
Yes. Which is factually incorrect, madam. Because the first appellate authority found that the entire thing was manipulated.
Before us, what is the material to show that you are from that area?
I have given my all the documents showing that's the certificate of the Tahsildar certificate.
How Tahsildar will give certificate?
I am
Whether you are
father's house, madam. I am residing with my father's house.
No, you are mentioning about residential certificate.
Yes.
Residential certificate is issued by whom?
By Tahsildar.
Which law?
Under the miscellaneous certificate rule 1984.
Then which section?
That is, my lord. That kindly say page 21. That certificate is annexed.
No, we are asking you. Tahsildar issues that certificate under which provision of which act?
That is, my lord, miscellaneous rule.
No, find it.
Show that I am a stranger to you.
I understand, my lord. That is, my lord, in terms of rule 6 of that particular rule.
Read.
I have not got the book. I am sorry, my lord. Let's make KG.
Because this question arose before the apex court in Manmohan Singh versus Election Commission to decide whether a particular person resides in a particular, because Representation of People Act Section 20 uses the expression who is ordinarily residing in the constituency.
There are some case, that was.
No, that is also one of the condition in this case. That is also one of the condition in this.
Yes, the advertisement says that.
The resident of that service area.
Well, and only one thing, apart from that, I'll show to your lordship what the rule says and how I have got the certificate and what is my factual position in reference to not only that document, other contemporary document. The advertisement says if any has
ration card, voter's list, driving license, and such other notified documents, there are 15 documents based on which whether a person is of that area or not is decided.
You are saying absolutely correct.
Which of the documents you have produced?
My lord, I have given document, my lord. Kindly have a glance to page 21 of the petition. I have given, my lord, educational
document. We are asking you.
That is, my lord.
That's the only case.
Yes, yes.
Nothing else. If you show that you are from that area, you have got 459 points. So naturally you will be given an appointment.
My lord, I have given documents, my lord.
What documents you have given?
The residence certificate, Sarpanch certificate, the local Sarpanch has given the certificate. That
which section he gives the certificate?
No, because he is the Gram Panchayat head, my lord.
No, you can't argue like that.
I'm not saying that.
This under the act, if you show, otherwise for anything, for money, anything, anybody can be getting the certificate. That's not the point. Where is the designated authority who says you are residing here?
Well,
otherwise, no, anybody can become resident of anybody, any place.
No, other certificates will
show that. Voters list you can show.
Yes.
We have voters list. What is voters list? Voter list.
Yes, but it is there.
Where is that?
Where is that?
But it is not annexed, my lord, to the read appeal. I'm sorry, my lord, that is not.
Do you have ration card?
My lord, all the documents are there. I have filed in the read petition, my lord.
No, we'll find it. Where is that?
We'll look into that one only. Whether your client is married?
Yes.
When marriage?
Then marriage, my lord, I am staying with my husband in my father's-in-law house.
You are staying with your husband?
And where is otherwise staying? Obviously, you will stay with the
matrimonial home.
No.
Or in parental house?
My husband, my lord, is residing with me in my father's house. There was a dispute.
Is it Aliya Santana is available here? In Aliya Santana,
yes,
it is applicable only to Kerala, where after the marriage, the son-in-law goes to wife's place. You convince us that you are residing in that area based upon legal documents, not some sarpanch give, some member give. That makes no sense at all. Otherwise, everybody can.
But I'll make that compilation. I've not brought the original.
After 2 weeks. Available counsel for the.
Only one thing, madam. Both the appeals have been both the petitions have been dismissed. My allegation was against the opposite partner, DP of that area. He manipulated the records. Only one.
We want you are before this court. You have to convince this court.
And after dismissal, she has been continuing. Even after dismissal of both the appeals by the second appellate authority.
That we will see. That we will see.
Yes.
After 2 weeks.
After 1 week.
1 week. No, 1 week. We have posted many matters. Yes.
Item 17.
You have to show those. You will get it under the RP Act, which all documents should be shown to prove that you are resident of that particular area. Voters list, ration card, driving license, school certificate. But after marriage, the presumption is the wife goes to husband's place amongst Hindus because Sita Mata followed Rama's steps even in forest.
It is Muslims, Muslims.
So you show that even amongst Muslims also. Paiji writes it.
Yes.
My wife goes to husband's place. Paiji's principles of Mohammedan law, outlines of Mohammedan law. Famous book. He says wife goes to husband's place. Yes. May please look.
Item 17.
Yeah.
Lordship, kindly see the order dated 21/8/2025. Order dated 21/8/2025.
Your petition is dismissed.
No, of this honorable court. You will
So that we are saying, why you are before this court?
Yes. No, I am before this honorable court in the writ appeal challenging or passed by the honorable single judge. Your Lordship, kindly see the order dated 21/8/2025 in this present writ appeal, wherein leave was granted for filing this appeal.
Yeah. Last time,
my lord, yes,
we told you.
Yes, I am ready.
64 Supreme.
61.
60?
61.
61?
No. Shridev Singh and others.
Shridev Singh versus Swine Face, 61.
I know.
You have that. You have to go before the learned single judge and say, because he has already heard the matter, he will be knowing everything. And matter is still pending before the learned single judge.
Yes, and I have gone through that judgment, and the recent judgment of the Honorable Supreme Court, May
63 SC 1909, 61 SCC online. It's a 5-judgment decision.
Madam.
Yes.
And I am relying upon a recent judgment of the Honorable Apex Court. Let me kindly tell this. Wherein the Honorable Apex Court has been pleased to hold that paragraph 16, 17 is the most relevant, Lord.
2025 judgment.
Madam.
Any change in the law?
So, may read paragraph 17.
Paragraph
17, 17. Madam. In our further considered opinion, the law laid down by this court in Srimati Jatan Kanwar Kolcha versus Kolcha Properties Private Limited and State of Punjab versus Amar Singh that the appeal could be preferred with an application for leave to appeal, provided the non-party appellant demonstrates that either the order under a challenge is prejudicial to his interest or adversely affects him or is binding on him would be applicable. Also, the maxim ubiquitous remedium cannot be ignored. A party suffering an adverse order in judicial proceeding where he is not noticed because he was not a party cannot be left without remedy. Although he can apply for the review, the scope of review is much narrow than an appeal and would not provide a remedy as effective as an appeal. For the foregoing reasons, we hold that where an allegation of non-joinder of necessary party is raised in an inter-court appeal, the High Court, if satisfied that such allegation has merit, should either remand the matter to the single judge or decide it on the merits. Such an approach, while not mitigating against the subject and purpose of Rule 5, would at the same time accord with the maxim UB just IGB.
Appeal is maintainable. We need not go. Yes.
And with regard to merit of this case, Miller,
Yes.
we are the slum dwellers, Miller. We have been staying over the land in question for more than 30 years.
The land is of the government. Government land.
Miller.
Where is the material to show that you are residing in that land?
And the authorities have issued under Slum Dwellers Act 2017,
So that
already annexed, Miller. You may kindly see, under Annex 3 series, though it is in ODR, but it has been issued under the Act, Slum Dwellers Act.
let's translate that.
Miller,
Who has issued this?
this has been issued by the Executive Officer, Jalsur Municipality.
Who is the authority to issue such certificate under the act? Which act? You mentioned some act.
Yes, sir. On the
Which
land,
act?
I have to hand it over the, it is with the Lordship.
Land Allotment Act.
No,
Land
Miller,
Allotment Act.
Slum Dwellers Act.
Slum Dwellers Act. Where is the slum?
In the land, I have given, but
No, where is the slum? There should be an area declared to be slum area.
yes, Miller.
Then the rest of the things will follow.
Yes, Miller.
And
And
where
the
is
government,
declaration that this is a slum area?
and this honorable court was pleased to call for a report from the government. It is with the Lordship's plea. Lordship may kindly peruse. It is there.
Slum area.
My lord, before your lordship said delving into the merit of the case, my lord, may I be permitted to on the question of a merit? I'm so technicality because he is to approach the London single judge seeking intervention.
No, that's now he has brought. I was also under the same impression. In 2025 judgment, there appears to be slight deviation, saying that when appeal is filed, the division bench should hear the appeal instead of sending him to the review because review jurisdiction is.
No, not review. His only allegation is he was not heard before the single judge. He was not a part.
The order is contained.
No. Because he is to avail that opportunity before the London single judge. London single judge can decide this slum issue. You were before the London single judge because we are not unaware. He is to take that stand.
Appeal is pending now. The petition is pending.
Yes. The petition is pending. Yes, that way I am seeking.
Yes, Miller.
He has to raise this issue before the single judge.
Show. Show.
Ah.
He has prima facie right. You have to show that this area is covered by the Slum Dwellers Act, which is that act which you said. That you have to show, not just certificate.
Section 3.1. Section 3.1, Miller.
1 second. The Act may be called Odisha runs to Slum Dwellers Act 2017. What is meant is slum dwellers.
I have highlighted that.
These acts, I know thoroughly will not. There is a survey preceding that he has to be declared a slum dweller. There is a survey to be undertaken by the concerned authorities. First of all, to satisfy the lordship, he has to produce the certificate that he is a slum dweller.
That he has produced. He has produced that certificate.
Produce the certificate.
And Miller, further, the government report is there. The earlier bench, it is with the lordship's because this one directed the state council to produce the factual report, and the report is already with the lordship. Lordship may kindly peruse.
1 second. Slum area means a compact settlement of at least 20 households with a collection of poorly built tenements, mostly of temporary nature, crowded together usually with inadequate sanitary and drinking water conditions, which may be on the state government land in an urban area. Where is this declaration that it is a slum area?
The report is there. Government has filed the report. It is with the Lordship's brief because Honorable Chief Justice and they have called for the report and it is with the Lordship.
We don't find it in our report. Which report? In the first order, it was directed.
Yes, yes.
This, have they produced those documents?
Yes, yes.
You look into it, you tell them. Give the file to him. Otherwise, all property will be allotted to people of the political parties.
No, but that is not.
We are saying that.
Man.
With our experience.
Man.
Therefore, unless you show that this allotment is made to you, we will not. Upon allotment should be shown to have been made in accordance with law. No, if some secretary gives some certificate, we will not act upon that.
No, my humble assumption would be before the Honorable Single Judge, even if we are named in the writ petition, but we have not been made parties.
You make application for impleadment.
No, but why we come before this Honorable Court immediately, my lord? Because the Honorable Single Judge, while keeping pending the matter, directed that you evict within 10 days without issuing notice.
You filed application,
my lord.
Two applications. One for your impleadment, another for recalling that order.
For
why we
variation.
should interfere when the matter is pending before the learned single judge?
For variation.
Till then, my lord.
No, nothing like that. You do instead of spending time here.
You not kindly see the order of the Honorable Single Judge.
Yes.
In the
He
matter
has
of
directed the Tahsildar,
yes,
the concerned officer.
On the first date of hearing, my lord.
Maybe you go and tell him. On the first date of hearing, you should not have passed order. You should have waited 100 hearings. Then you could have made that order. Therefore, you recall that order.
Yes, my lord. That is the procedure.
That is the procedure. We will not interfere.
No, I'm not seeking for interference of this Honorable. You will also kindly bear with me. Because in view of the present Supreme Court decision.
That is pending before the learned single judge. Will not interfere. This intra-court appeal is filed by a person who is not a party to the proceedings in WPC. So, wherein the order has been issued by the learned single judge. On the learned counsel appearing for the. Who are you?
Lord, I do have power.
Sit down. He has argued already. Fine. Learned counsel appearing for the appellant vehemently argues that.
Well, there are appellants, plural, my lord. They are in four in numbers.
Vehemently argues that his clients have been in the occupation of the subject area, which is area, and that they have been issued which certificate it is?
Under Slum Dwellers Act 2017.
Issued certificate.
Under Annex 3C.
No, will be issued to you. This is not a certificate.
My lord, it is an eligibility certificate.
Eligibility certificate.
Because, my lord, we have been staying there for last more than 30 years, my lord.
That is not granted.
There is a statute.
More so,
according to procedure, they should go. Otherwise, all workers of the political parties will be issued certificates. Lands will go to them, and they will hold the certificate because they work for the political party. And genuine candidates will not get the land at all.
The report of the Tahsildar, which has been.
Anyway, we are not looking into all
for a moment.
You go and before the single judge, matter is still pending.
And the Honorable Single Judge, the last date of Lordship kindly see what order has been passed by the Honorable Single Judge. May I just read, my lord? It is 13/1/2026. The Honorable Single Judge has been pleased to hold that Mrs. S. Rathalan counsel for the petitioner submits that against order of this court dated 18/7/2025, state has preferred an appeal, and that is W number 3174/2025, which is still pending. Accordingly, he seeks for adjournment. This court finds that in the event the writ appeal is allowed, then there will be nothing to decide in the present writ petition, and in the event the appellants do not succeed in the writ appeal, then there is nothing more to decide in the present writ petition in view of the order dated 18/7/2005, because this is the order which is under challenge before this honorable court.
Therefore, we are telling you to go before the court. You are not a party to this.
My lord, the final order has been passed.
This judgment which you have cited now is not applicable because there was already disposal of the matter and review will not be possible. It's not a case of review. It's a case of implement.
Well, the order which has been passed in shape of the final order. And
what else? Submits that the adverse order is passed against his clients without opportunity of hearing, and therefore there is a gross violation of principles of natural justice, warranting interference of this court. First of all, he also tells us that all the appellants hold the eligibility certificates granted by some executive officer of municipality, and therefore their occupation is not illegal. First of all, he also cites a decision of Apex Court in Abhishek Gupta versus Dinesh Kumar, 2025 SCC online, SC 2739, to the effect that the appeal is maintainable and review is not a proper remedy, adequate remedy, is not an adequate remedy regard being had to the constraint of review jurisdiction. First, learned AGA appearing for the official OPs and learned madam appearing for
Respondent number 6, who was the writ petitioner.
Respondent appearing for OP number 6, respondent number 6, who happens to be the writ petitioner, opposed the appeal on the ground that still the writ petition is pending and therefore it is open to the appellants to seek impediment and also recall of the order on the grounds that have been urged before this court. First, next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter in as much as the appellants can seek redressal at the hands of the learned single judge before whom the subject writ petition still pends. First up, in that connection, all contentions are kept open to the appellants. First up, the decision in Abhishek Gupta is not invocable in as much as that was a case where the petition was finally decided and therefore review was held to be inadequate. However, in this case, petition is still pending. First, next paragraph. In the above circumstances, this appeal is disposed of with the observations herein above made.
Extremely grateful, Your Lord.
Yeah.
Item 18.
Keep that judgment, give it. Make notes of this judgment and put it to my notes.
On the last occasion, Your Lordship have directed the respondent is to address. But before that, I'm just taking the facts in nutshell. Again, refreshing.
You are for the appellant?
Yes.
Just refresh our memory.
Refreshing, Your Lordship. Now, the petitioner is a small scale small scale industry registered under the MSME Act. In 2017, it was awarded with.
Make use of mic. Many youngsters are sitting in the court hall. They want to hear good arguments from the
I have some throat issues. So in 2017, the work was awarded by the respondent number 1 in our firm.
You are MSME.
I'm MSME. Your work was awarded by the respondent large unity in our favor in 2017.
Which respondent?
Respondent 1, only one respondent in fact. Sole respondent.
Corporation.
Yes, madam. Yes, madam. Sole respondent.
What work was allocated to you?
There's some tank, oil tanking, tanker manufacturing, installations work. That's not in dispute. I'm just carrying through that. That work was awarded.
Yeah.
Now there is some dispute out of it.
Yes.
Now I invoke the jurisdiction of Micro, Small and Medium Scale Enterprise Facilitation Council, working under the MSMED Act 2006. Now the council passed an award dated 10th July 2023. Lordship, my date chart, it will be better. I have already.
23. That Arbitration Act is applicable to
Yes, my lord. That 10 July 2023. And this was not an ex parte award. It was parties have made there. The award was passed. Now, the award was sought to be challenged under Section 34 after lapse of about 174 days of the period limitation. So that 28th March 2024, it was 34 application was.
This is a matter which a Delhi lawyer had argued.
Yes, yes.
Yes, both of us.
Yeah.
You had argued, sir.
That is. Then, my lord, that application was withdrawn unconditionally. Unconditionally withdrawn.
Then execution was put and in execution.
Then execution was continued.
Bodies without jurisdiction.
Execution, yes. Then they
Kiran Singh versus Chaman Lal Sahu, it's a 54 Supreme Court. Yeah.
So then they filed this application assailing the award passed by the tribunal or the MSCFC.
Yeah.
That's under the challenge. And the single judge appreciated factually, I'll now say it actually, that it's a worst contract. Therefore, the MSFC has no jurisdiction. Now, in doing so, the honorable single judge has lost sight of the fact that this plea, that it is a worst contract, was never before with any forum in the country. That's number one. Number two is, my lord, even if it is it was not raised and it was raised directly for the first time and seeking interpretation of the contract, we have shown that this contract, the benefit to the MSME has been awarded by the very same respondent in the impugned tender.
Understood.
So, therefore, the last drawing that the first division bench has, in order dated 7th January, has framed two issues. That's not.
Yeah, may I please move? Lord, I have a small date chart because my lord had a query.
You have argued the matter. Any new thing to be added?
There was one pointed query from the bench, my lord.
Yes.
Which was, once I have withdrawn my 34 without liberty, whether it comes in my way of raising this kind of an objection in a writ petition.
Yeah.
At that juncture, I had pointed out to the Honorable Court that it is not a case where I'm filing a 227. Here is a case where an execution was filed and I filed a 47 objection there. Lord, I may just read this 5-7 dates for your lordship's convenience. It will put the things in perspective.
Yes.
Lord, 2017 work order was issued. Your lordship may see me.
You are for respondent.
I am for the respondent.
Who was the writ petitioner?
Yes, the writ petitioner.
Your lordship may please see page 53 of this compilation.
53?
Yes, my lord. Oh, sorry, no, of the writ appeal, my lord. I'm sorry. Page 53 of the writ appeal.
Yeah.
Lord, the learned single judge under 227 only observes the special conditions of contract, the nature of work that my lord had precisely put to them. What is the nature of work? It was
assuming that it's a works contract.
It is a works contract, my lord.
Therefore, it is without jurisdiction, is your contract.
Yes, my lord.
Go to
Now,
next.
my lord, my lord, with this, their own document on record says there is works contract. Now, my lord, lordship may have my list of date. My lord, the contract was terminated in 2018, all right.
No, you withdrew your challenge under 34.
I'm coming to that one. I'm coming to the straight. I'll answer that, my lord. I'll not go anywhere. Just 3 dates are important. In 2022, my lord, after 4 years or 5 years, he approaches MSEFC. His claim petition says it is a service and supply contract. It is his plea. It is his plea. Lordship may mark, my lord, I have filed enclosure A, his claim statement at page number 10 of my compilation.
Yes.
My lord, 2023, an award is passed. The award in the analysis section records it's a service and supply contract. So there are 4 documents today. We have the SCC, the tender document which they rely upon, categorically says it is indivisible composite contract. Their own claim statement says the award says. So therefore, there is nothing which is controversial in nature, and they're in writ appeal. They still do not say that it is not a work contract. The objection is that once I withdraw 34, then 23(1) operates against me, and maybe because the Hon'Ble Supreme Court has extended it from res judicata to public policy, but they say that I perhaps cannot raise this objection anywhere else. Right? Now, my lord, for that, on facts, I will first make my submission. Your lordship may see the next date. During the pendency of section 34, 2 petitions are filed by them before the commercial court. My lord, one is in Cuttack. Both are in Bhubaneswar District Court, Commercial Court. Not one is execution, that is enforcement. The other one is under Section 9 of the Arbitration Act. Relying upon the award, they sought certain injunctions against me. But that is a collateral proceeding under Section 9, and execution proceedings are pending. But first, what I do is I first file an objection before execution court during pendency of 34. I have not withdrawn it. I file an execution before 34. First ground I take is that it is unstemmed. And Lord, that question will come, because if my lord were to allow this appeal, then my lord, there are so many other questions in the second petition which have not been answered because it has already been held to be a work contract. Then my lord, it has to go back. Now, then my lord, I file a supplementary objection, whether under 47 or otherwise, my lord, nullity is a nullity. Even if 47, my lord, Supreme Court has reaffirmed recently in 2025 December judgment that 47 objection is maintainable. My lord, in my case, the commercial court said that Bharat Chand of this honorable court, my lord, said that 47 is not maintainable, but I'm not getting into that controversy. Even if 47 is not maintainable, there are many judgments which says that a nullity, any court, superior, inferior, can declare it to be a nullity in any proceedings. I'll come to that, my lord. Now, my lord, I move to execution court. I take this objection there. And I say on many folds, but not on those grounds, those jurisdictional errors which could be waived. Because if it is such an objection, then I would have taken it before the forum first. And if not taken, then under section 4 of the Arbitration Act, it would have been waived. Even 34 is not available to me. But those jurisdictional errors which are inherent, where, my lord, my consent, my plea is immaterial, we together cannot confer that jurisdiction. My lord, that objection, and they were twofold. My lord, when that was pending, I also moved, my lord, an ex parte under section 9 was passed, issuing injunctions against me. So, my lord, there also I took this objection saying that this is not enforceable. And if you are passing an order based on an award, you have to answer this. My lord, while these were pending, obviously, my lord, there was a limitation. My lord, my client sought an opinion. It was beyond limitation. So, my lord, it was withdrawn. 34 was withdrawn. In section 34, this objection was unfortunately not taken. But whether taken or not taken, my lord. Now, my lord, so now 2 things happen. 1, my objections are pending before execution court, before section 9 court. My client, by way of abundant precaution, also filed a 227 directly against MSME's award. That is the first writ appeal before my lord. My lord, the execution court says 47 not maintainable. In view of Bharat Chand's, my lord, which I will show, my lord, with due respect, it is per incuriam, my lord. Sorry.
Award came to be passed on.
My lord, award was passed on 10th of July 2023.
You filed 34 on?
My lord, I filed a 34, my lord, exact date, I will just give it, my lord. It was.
Its number is?
Yes, my lord, I'll give it.
20th of March 2024.
Yes, my lord. It is arbitration petition number 11 of 2024, 28th March 2024. It's in the date chart.
28 or 28?
24.
24.
My lord, it is 23rd of March 2024.
20th of March.
Award is passed on. Yeah. This is on 10/7/2023 by MSME Council. First off, it is passed after with the participation of respondents. They will hear it. Next point. Award was challenged to Section 34 of Arbitration Act. A challenge was filed on 28th March
2024.
2024. First time. In arbitration appeal number, what is that called as?
My lord, that is arbitration petition number 11 of 2020.
Arbitration petition number
11
of
2024.
24. That came to be unilaterally withdrawn by the respondent on
my lord,
21st October.
21st October. The order is dated.
Yes, ma'am. 2024. First time. Thereafter, what you did?
My lord, before withdrawing, I had taken this objection before execution court as well as before Section 9, and before this order, I had approached this honorable court under 227.
In the meanwhile, execution petition was filed
by them.
EP number?
Number, my lord, is
585 of 2023.
Yes, my lord. And a Section 9 petition. It was, my lord, may I get the date?
Wherein objections were taken by the respondent, resisting the execution on the ground of award being nullity.
Nullity and unstand, both.
And unstand. Next one. Section 11 9. Section 11(9).
No, Section 9.
No.
Only Section 9.
Only Section 9. Section 9 petition it was.
Yes,
That was case number?
Arbitration petition number 29.
Arbitration case number 29
of 2024.
2024 was filed by
them.
Appellant hearings.
On 22nd March 2024.
Under Section 9 of the Arbitration Act.
Yes.
On
22nd of March
2024. First off. Even there, the respondent has taken the plea that the award itself is a nullity, and therefore petition is not maintainable. Nothing. Then what happened?
My lord, then, my lord, 1/227 was filed before this honorable court directly against that order.
Against which order?
Against the arbitral award.
Oh, on that you filed WP.
My lord, we filed under 227.
That's what.
Yes, ma'am.
Petitioner, the respondent filed a WPC number.
Yeah, WP number. 30966.
2024.
Filed on 26/11/2020.
On 26/11/2024. Under Article 227
yes, my lord.
of the Constitution. Perfect. That has been allowed.
That is allowed.
And against that appeal is now.
There are 2 appeals here before me.
One more appeal.
Yes, my lord. So that is the first petition. I succeeded there. Then, my lord, in the meantime, my object.
This petition is allowed with the learned single judge.
Yes, my lord.
By the impugned order.
Yes, my lord.
Then there are 2 appeals now here.
Yes, my lord.
Now, one appeal is against this. The other appeal is against.
I lost it before the Honorable Commercial Court. Because the Commercial Court, my lord, on the strength of Bharat Chand's judgment of this court, said 47 is not maintainable, inter alia and other grounds. So, my lord, I challenge that before this Honorable Court under 227.
The Commercial Court order?
Yes, my lord.
That Section 9 order?
No, execution.
Execution order.
Execution.
Execution was issued in what form?
Milord, execution, Milord, enforcement, my applications raising these objections were dismissed.
That you had challenged.
That I had challenged.
The execution courts dismissed the objections. While order dated?
Milord, there were two separate orders. One was 22nd. Milord, I'll just give.
Why two orders?
Milord, so first they
One is
disposed.
stamp and another
Yes,
is
yes, Milord.
dismissed the objections as not maintainable. While order dated?
Milord, first is 22nd of.
No, not maintainable. You cannot take up that contention. Which order it is?
Milord, that is 19/6/2025.
While order dated 19/6/2025. First one. Petition the objections of the respondent to the execution on the ground of non-stamping of the award.
Everything was taken in that.
Is also rejected by another order, by the same order.
No, Milord, that is a previous order of 20.
By the order dated
22nd/9/2024.
22/9/2024. 22. First one. You had filed a separate writ petition for this.
Single writ petition, Milord, both the orders.
Yes. Both these orders were challenged before the learned single judge in WPC number 309996.
No, Milord. It is
20210 of 2025.
20210 of 2020.
This is the second writ petition.
Filed on 18/7/2025.
Second writ petition.
Second writ.
One, you had filed a petition challenging the award.
Direct award.
The second one is what happened before the learned execution.
Yes, my lord.
Understood.
My lord, in these set of facts. Now, my lord, before I make my submissions, my lord, on your lordship's pointed query, I want to read one judgment of Supreme Court.
Please.
Because, my lord, it suits me. Otherwise, the law is well defined.
Tell.
My lord, I will pass on this judgment. This is AP Payappa Sastry versus Government of Andhra Pradesh.
Was it a matter relating
2007
to
taxation?
Taxation matter? No.
No, my lord, not taxation. Sealing and Regulation Act. 2007 4 SCC 221. I just want to read one particular sentence because, my lord, my entire case, I feel, my lord, would be covered by these sentences.
Without jurisdiction.
Without jurisdiction. My lord, there are so many things. My lord, their main contention today is that I am here only to circumvent the limitation.
Yeah.
And
Which
before
is that,
yes,
My lordship may have it. This is a compilation handed over. My lordship will have it at page 184. This is A.V. Papiya Shastri versus Government of Andhra Pradesh.
Famous judgment papers.
Yes.
184.
2007 4 SEC 221 and para 22.
What's the comparison?
That's the first one.
Your lordship, may please have paragraph 22, my lord.
How many judges?
This is
Two judges.
two judges, my lord. Justice.
Have they referred to? Have they referred to the 92 Supreme Court? 92 is 3-judge bench. Which other day you read that?
Yes, yes. No, my lord, they have not referred to. But I will answer that, my lord. Your lordship is right, my lord. I have examined that issue and that absolutely, my lord. But I fall within an exception, my lord. I will come to that. Your lordship may see para 22. Although, my lord, in this case it was fraud, but the ratio is when a judgment or an order is a nullity. And again, my lord, I wish to clarify myself. When I am dealing with nullity, I am conscious. It is nullity as in it is inherent lack of jurisdiction, not irregularity in jurisdiction or irregularity in exercise of jurisdiction. No. My lord, what it says is such a judgment, decree or order by the first court or the final court.
Listen to me.
My lord.
Fraud from the days of Lord Edward Coke
Yes, my lord.
stands on a different footing.
Certainly, my lord.
It vitiates everything.
Yes, my lord.
That's what Apex Court said
Yes.
in Changalavarai and Aidu versus Swine following Coke's statement.
Yes, my lord.
Nullity, because it is a fraud on public law, is one thing.
Yes.
It is a order without the inherent jurisdiction itself, initial jurisdiction itself is another.
That's what. I will put it within that narrow compass, my lord. I am conscious of it. I will not raise the jurisdiction.
Therefore,
Yes.
there are two different things. Terror on fraud
Yes.
treats this subject.
Yes, my lord.
An order of the court being a nullity because of the fraud of Coke's version.
My lord, that is why I pointed out.
That's one.
That is why I pointed
An
out.
order without jurisdiction,
Yes.
different parameters.
Absolutely. And there could be two kinds of inherent lack of jurisdiction or otherwise, my lord.
Now,
But my lord, what I want to read is If it is nullity, then by the first court or by the final court,
It's a nullity.
has to be treated as nullity by every court, superior or inferior, full stop.
Which
It can be challenged in any court at any time is important.
take us along.
Sorry, in para
Take
22
us
and
along.
yes, yes.
In the compilation, my lords, it's at 197. You will have para 22.
Para 22.
197 of that spiral compilation.
197.
197, printed page, and para 22.
Is the settled proposition of law that judgment, decree, or other obtained by laying fraud on the court, criminal authority is a nullity on non-esteeable such a judgment. But this is not a matter of fraud.
Lord, it is true. It is not. But what I'm trying to focus, Lord, I'll try to bring
Applies to the this principle applies to the case of nullity also.
Nullity also. That's it. By the first court, by the
Yeah, they have quoted Justice Edward Coke only.
Yes, following that. May I just read these two lines, my lord, if my lord permits me?
No, understood. I read that.
It can be challenged in any court at any time.
Even in collateral proceedings, is also a judgment.
My lord, here is the case, and I will come to that Sarguja transport, my lord, at the strength of which my learned friend has taken objection. Now, my lord, here is a litigant who has done everything possible, approached every forum possible, with a sole ground that MSME cannot exercise jurisdiction in a works conduct.
Yeah, understood. Next point.
Lord, now their point is that since I've withdrawn it unconditionally, public policy should affect me. The other day, I made 3 submissions, although it is hinging on the first submission that I just made. There could be 3 circumstances and which fell before honorable courts. One is where 34 is not filed at all. Courts have said immaterial. If it is inherent lack of jurisdiction in 37 or in
nullity is a nullity. Your worship.
Second is I filed a 34.
Did you say while withdrawing that 34 petition? Did you tell the court since award itself is a nullity, I don't want to press this petty challenge?
My lord,
I'm asking.
No, I did not say that.
In the withdrawal memo filed for withdrawing the challenge under section 34, counsel appearing for the respondent very fairly concedes that the ground of nullity of award was not taken.
Just one 34 also it is not taken. I'm just trying.
Yes, it was not.
34 petition it was not.
On this point,
you have not taken up
not
that.
taken 34 also.
He also very fairly says that even in the challenge under section 34, such a ground was not taken.
Not taken. No, Lord, my respectful submission is when I moved an application on 24th last year to withdraw that. Before that, my challenge before execution court on this ground was pending. So, my lord, the question of waiver in any case doesn't apply, and this kind of a inherent lack of jurisdiction, when this question arises, it cannot be waived. That itself is a question to take.
Inherent lack of jurisdiction cannot be waived, and that parties by their consent no jurisdiction they can confer on an entity. Next point.
Yes, Lord. Lord, now the honorable single judge, my lord, in the award only sees the contract and says that yes, it is a work order. And he deals with the proposition that whether 227 is directly maintainable or not. And he holds in paragraph 3940 that a recourse to 34 is not necessary when a tribunal or a court below lacks jurisdiction. No, that is the. Now, my lord, after this judgment was delivered, the other writ petition was pending. In that writ petition, my lord, certain interesting questions were raised, which was obviously not decided because he has already cost this award, set aside.
That is also an appeal here.
Yes, that is also an appeal here. Obviously, my lord, because but it is my duty to point that out because, my lord, in the event, this honorable court, that is the second writ appeal pending. My lord, on the last occasion when I pointed this out, my lord said that should also come here. Then it was served.
So it had come now.
That is how it has come. Yes. Now, my lord, in that writ appeal, there are certain very important issues were raised, which are of public importance as well, my lord. May I just read those ground issues, my lord? Whether objections under section 47 CPC are maintainable against enforcement of arbitral law. It may be academic today, my lord, but whether the law laid down by this honorable court in Bharat Chand Nagar versus Orissa Magnesium is per inquirium being contrary to the settled law by the honorable Supreme Court in so and so judgments. Whether a court can refuse to enforce an arbitral award when the tribunal inherently lacks jurisdiction. So even if 47 is not maintainable, various high courts have had that no, we will not turn our eyes blind. Fourth issue was whether the issue of inherent lack of jurisdiction can be waived.
All these are all second year law.
Yes, that's right. But why? Because all this has come against me in the commercial court. So now, my lord, I succeeded in the first petition. The second petition, the learned judge says that I have already decided, I've taken a view. It is a work contract. And therefore, it is set aside. I'm reiterating that order here also, and it is disposed of that. These are the total facts of this case. Now, my lord, even in the writ appeal, it is not their case that it is not a work order. It can't be. And my lord, I had the privilege of hearing this bench, my lord, today morning. My lord made it very clear that a writ court will generally not dwell deep into the controversial facts. But if it is discernible on the face of it,
we are entitled to look into.
Now, my lord, their own document says that I am composite work order. My lord, it is the duty of the court which, my lord, initiates to, my lord, look into it. My lord, I'm so sorry to say, it is correct that I have not taken that plea. My lord. It is a miss. But then, my lord, I could not have conferred jurisdiction, my lord, under any proposition of law. My lord, I rest my submission then. Not just one more issue.
Just one issue, my lord, on this work contract. Just for the sake of completeness, if my lords have the compilation, because since my learned friend said this work contract was never taken up or brought up, now documents signed by the partners, if my lords have 103 of the compilation matters. Now this is exchanged with the parties. By the parties which clearly say it's a work contract, because when they
but that you did not, that contention you did not take up before the arbitrate council. You did not take up that council. You had 5 battle lines were drawn up.
Yes.
We did not take up the contention that it's a works contract and therefore the council lacks jurisdiction.
Before the council we did.
That's what. What other things to do? What happens before the statutory? What is the arbitrary? That's the statutory council. It is not even a private arbitration. It is under the MSME Act. Though the provisions of the Arbitration Act are applicable, when you should have taken up the contention, because of this, the arbitration itself is not possible. So that tribunal council could have ascertained whether there is a works contract or not. He might have stated in one line, etc. But question is, what were the issues framed before the tribunal council?
Yes, ma'am. Yes, ma'am. It's in my writ. This issue was not framed now. This was not an issue. Your Lordship is right. Lord, just one thing, Lord, I will only stick to it.
That issue was not framed because the pleadings draw the battle lines.
That's right. And in the pleading, in their claim statement, they said it is supply and service contract.
But therefore, you should have taken up the contention. They have admitted like this, and therefore they have no jurisdiction at all.
Lord, I agree, Lord. But that is what I'm saying, Lord. In such a case of inherent lack of jurisdiction, where it is apparent that it's a work contract, even, Lord, under one of the cases in Supreme Court, Lord, recent judgment.
Yeah.
Lord, I'll just take one more minute. There's one more objection to it. Whether writ appeals are pending, Lord. My Lord had observed the other day. I am under 227, Lord, in both the petitions. And, Lord, they have filed writ appeals, Lord.
Let us see. Counsel submits that intra-court appeal is not maintainable since he had filed the petition under 227, under Article 227. This court has to ascertain whether the petition treated by the learned single judge was 227 or 226 or both.
Very good. Okay. Obliged.
Small rating note, I will permit the rating note I can.
Written submission.
No, you should have come along with that. Now I will not give time. I will announce it tomorrow. I don't know how much time we need for this. We would have given the dictation here itself. But we need to.
We have it ready if Lordship wants, not be.
If we can, we have written submissions already.
Yes.
My Lordship.
Yeah.
She was prepared on the last may not have.
If that is all right.
Obliged.
Yeah.
Lord, may I just place one fact on record, Lord? Lord, after these orders were, the award was set aside, liberty was granted to the parties to take recourse as per the law. We have already filed, because we also had a counterclaim before the tribunal there, so we have already invoked arbitration, and Section 11 petition is pending before Honorable Delhi High Court, where we have taken a date on the ground that the
Counsel for the respondent submits that. Section 11 petition is filed before the Delhi High Court after the orders, impugned orders were passed by the learned single judge, and the same is pending.
There is a coercive action, and as a consent, the coercive action has been stayed or by consent. The Lordship have observed in the last order. There is the interim directions that they will not take any coercive. That's by.
I want to place on record, my lord, the bank guarantees have been invoked.
That's already accepted.
The order that the injunction order that they took, my lord, under Section 9, that has been vacated. So, my lord, nothing survives, my lord, as of today. We have what has gone.
We may launch it tomorrow or day after. We don't know. Yes. Supplement is not possible today. We have many orders to this also. Yes. Any short matter for 10 minutes, which we can take up? Sure. Short matter.
Identical and 4 matters already been disposed of by the coordinator.
Which is that?
9 item 2, patients.
He says it's a covered matter.
Petitions were disposed of in a common judgment manner.
Serial number?
33 and 35.
33 and 35. You copy who appears for the other side?
Statement. Leading case, writ appeal number 119. Then second is also followed by that. 41.
You are in appeal.
Well,
you are in appeal.
Appeal, man.
No, you are in appeal against the order of single judge.
Yes.
Another party was against them. This is the Honorable Chief Justice's order. Yes, Mr. G, the order runs into 79 pages. It appears to be covered. Just I read the gist of the order.
2.9, para 2.9 minute. Here this 2.9, page 8 of the main judgment matter. Item 3. This arises out of writ of writ petition number
2237 and 2245. Very same.
Very same, my lord.
Yes. Kindly come to 2.9. Paragraph 2.9. They have mentioned this way, this petition also.
This is that
drivers. Drivers.
The minority managed institution? No. The minority managed petitions were dismissed in a common judgment. And 4 writ appeals are already been allowed. And these two 983.
But they have to take a decision. Liberty is reserved to them to take the decision.
My lord, findings is
in the lights of findings.
Yes. And my lord, the second common order passed by the another order I have given.
Driver.
That is
this follows this judgment.
Yes.
Leading judgment is this one.
Yes.
So we'll quote this one.
Yes, ma'am. In that case also that was quoted, ma'am.
Correct.
Relief short driver. It's regularization of driver. Sambalpur. With a
Right now, these intra-court appeals are directed against a learned single judge's order. Common order it is.
Yes.
Common order. dated 17/12/2024. Just correct me if I am in fault, okay? You have to correct me if I do mistake. Yeah. Dated 17/12/2024, whereby the appellant's WPC number 2157 of 2020 and another WPC also.
Also, my lord, that is below. Page 20, your lordship may comes.
2157 is one.
That is the leading case.
Another one is?
Another 2159, 2160.
So these appeals, your appeals.
Yes, my lord. In my appeal petition.
Give the number, just right now.
In judgment, it was referred, my lord.
No, there are many other judgments also there. Many other petitions are also there.
These petition is a common judgment, man.
Common judgment. Tell the number. Yes, sir.
That is para 2.
WPC number.
In rate appeal 2.9, para 2.9, which I have shown, my lord.
No, only two petitions we have to.
Yes.
In WPC number 2237 of 2020 and 2245 of 2020.
Yes.
What is it? No, read the sentence, full sentence. These intra-court appeals are directed under this common order. Appellant's WPC number so and so, along with other connected matters, have been negative. First stop. Next paragraph. Learned counsel appearing for the appellants submits that the subject matter of these appeals are identical to the one in writ appeal number 119 of 2025, which 25 between Sri Prafulla Kumar Behera versus State of Odisha and others, and therefore the same have been allowed by the coordinate bench headed by Honorable the Chief Justice. Wide order dated 19/6/2025. 25. First stop. He also 25, whereby the appeals are allowed and writ petitions are allowed, reversing the single judge's order, which is put in challenge before this court at our hand also, since it was a common order. First stop. A perusal of the state judgment shows that the submission of learned counsel for the appellant is absolutely true. First off, there is no much dispute about the same from the side of government as well. Next paragraph. In the above circumstances, one more sentence. The operative portion of the coordinate bench order at the paragraphs 11.2 11.1 and 11.2 11.1, 11.2 and 12 read as under. That you have to put it. Right? And 11 and 12. 11 and 12. Judgment copy. Read as under. Next paragraph. In the above circumstances, these appeals are also allowed
terms.
On the same terms. Yes. You? Then. May not be. Which is the other set? This is the only matter. Only two.
33 and 35.
35 also same order.
Same.
But how many petitioners there were in the 35? Appellants are how many?
One man.
Only one.
And that is
that WPC number?
1261 of 25.
1261.
WP number was 2245.
Yeah.